Good morning, all. Good morning, Public Council. The Commission is in receipt of your witness statement filed yesterday and copied to parties. You will need to seek permission to file the witness statement out of time in support of the affidavit dated July 28, 2022 and filed on August 5, 2022. The Commission would have received your letter on the 26th of September enclosing a witness statement of Ralph C. Smith, an accountant. I believe that affidavit of Ralph C. Smith was also filed out of time. I believe you may wish to make an oral motion for the Commission's permission to receive into evidence the witness statement and the affidavit of Ralph C. Smith. That affidavit was submitted by Ms. Samantha Cummins on behalf of the Office of Public Counsel.
Thank you, sir. As I had started to explain from day one, I came into the matter on September the 19th, 2022. So when I came into the matter, there were certain things that had not been done because there was no one in the office to do it. Ms. Cummins, to my understanding, as the Chief Legal Officer of Ministry of Energy, the Energy Division, she basically just saw that Public Counsel was struggling and attempted to help. But by and large, there was no one in the office to do anything. So I'm craving the Commission's indulgence to ask that though we are out of time, we're only out of time because there was no one in the office that could possibly have done anything to submit the statements earlier. Actually, we also had a situation where the PS, the permanent secretary who was in the office, she fell ill as well. And there was a new permanent secretary who then had to come up to speed. So the reality of it is, sir, that when I came onto the job on the Monday, it's only then when I realized that we were in a situation where our witness statements were not properly in. We were in a situation where we had not, that's why we then had to turn around and try to file for the extension of time. So, sir, I do believe it, in all fairness, you were aware that there was a Mr. Sorry.
We're just asking for the motion.
Right, yeah, that's what I'm trying to do, sir.
Okay.
That's
So just make the motion. Just make the
yes,
motion.
sir. So, okay, sir. I am moving a motion that you kindly allow the witness statements, even though they're late, that you kindly allow them to be entered in so that Public Counsel can, actually continue the job, basically. And the motion also asks that if, sir, there's anything that may also be a little bit late because of the circumstances we found ourselves in, we're asking that you kindly consider allowing us to be able to have this information admitted. Thank you, sir.
In relation to the motion presented by Public Counsel to have this witness statement and affidavit be entered in, are there any objections to this motion?
No, Chair, not from the applicant.
No, sir.
Okay.
No, sir.
All right. So we accept the witness statement and affidavit of Mr. Ralph C. Smith.
Thank you, sir.
We now continue with evidence given by Mr. Blackman. So, Mr. Blackman, could you take the witness stand?
Good morning, Chair, if I may. I know that we're supposed to continue our team Watson Simpson with the cross-examination of Mr. Blackman this morning, but we wanted to propose based on statements made under the discussion of our motion yesterday concerning depreciation, that we go ahead and allow the applicant to bring their expert who they indicated was likely to have to leave the jurisdiction by tomorrow. So we are proposing that we are willing to have them bring him and we proceed, and then we can come back to Mr. Blackman if the panel so accepts.
Council?
Chair, we would certainly prefer that Mr. Blackman's, Mr. Blackman's testimony be concluded pursuant to your indication last week. We requested our expert to extend his period here if he could. The intervening hurricane made it even easier for him to determine that he needs to extend his period. And as such, he will be available until the end of the week. He leaves in the weekend, so there's no reason to disrupt.
Okay, thank you. So, intervener team, Watson and Simpson, you could continue with your cross-examination.
Good morning, Mr. Chairman. Are you going to renew the affirmation? Is that good?
Yeah, Mr. Blackman, you're still sworn. Affirmed, sorry.
Thank you, Chair. Okay.
Thank you, Mr. Blackman. Let's just go back briefly to the discussion on the self-insurance fund. That won't be that much longer. Are you able to confirm any of the information that we had requested yesterday related to the memberships of the various boards? Are you able to verify the membership of the current Barbados Light and Power Board of Directors? You had listed some names and said that you would have to.
It was just short by one, Karen Hutt. Karen Hutt. All of the other names were provided yesterday.
Thank you. All right. In relation to the self-insurance fund, kindly explain whether the generation plant assets are insured
In relation to the self-insurance fund?
at all.
Okay, not in relation to just generally.
Just generally,
Yes,
are they?
They are insured under commercial third-party insurance, correct?
And could you give us the cover, the extent of the cover of the generation assets in dollar figures?
And I couldn't give you that in dollar figures in this 10 seconds, but I could get that for you.
So we're requesting that, but do you have a witness that could give us that information? Mr. Jennings, perhaps?
Yes, by the time he comes up, we can have that information for you.
Thank you. All right, Mr. Blackman. Let's talk about sales in 2020. Are your assertion, excuse me, is that 2020 is an adequate test year, is that correct?
That is correct.
And would you describe 2020 as a normal year as it relates to sales?
No, it wouldn't be a normal year as it relates to sales.
Why is it not a normal year as it relates to sales?
Because the impact of COVID was that we saw a reduction in our sales compared to where we were in the previous year. So sales were lower than they would have been in the year before 2019.
I'd like to have some numbers in relation to that. So could you give us your number for sales? You refer to the previous year. What's your number in gigawatt hours?
In gigawatt hours, give me 1 second.
That's 2019.
In 2019, it was 944 gigawatt hours.
And in 2020?
It's 890.
And in 2021?
It was 905.
And year to date, so that's,
450. Well, to June, 450.
no, to date. So we
Don't have that.
put in an interrogatory requesting, and that interrogatory was filed at the end of August, requesting year-to-date sales. We expect that the company would be able to say at the end of August what their sales were year-to-date. So what's the year-to-date sales up to August 2021?
Was it provided in the interrogatory response?
Yes, it was.
So
If you provided a response,
Yeah.
you provided a response up to June. We're asking for a response up to the end of August. I think that's
Well,
reasonable.
I have June at hand here because that, in relation to the interrogatory response, I would have to check and ask someone to provide me with the figure up to the end of August. I don't have that at my fingertips.
Mr. Chair, we are requesting the figure up to the end of August.
I can get that figure from someone on my team and provide that
Okay,
to the interviewer.
so noted.
Mr. Blackman, based on your normal reviews of your operations, so you have Q1, you have Q2, you have Q3, presumably, can you describe, yes, explain to us whether you think that your sales projection for 2022 is either on par with 2021 or will exceed 2021?
Our sales projections for 2022 would be on par with what we've indicated in our 5-year forecast. I believe in our 5-year forecast in the application, we've provided a sales forecast from 2020 to 2025, I believe it is. 2021 is within 2% of the projection that we've made, and 2022 we're expecting to be within 2% as well, same margin of error as we would have projected at the time of filing. The specific figure, so I know generally that's the case, but the specific figure, I would have to look at
All right, so I'm
forecast.
trying to understand.
Mhm.
From your own projections, going forward, you project sales of 944 gigawatt hours for 2023, 953 gigawatt hours for 2024, and 996 gigawatt hours in 2025. Is that correct?
Just give me 1 second to find the forecast. Okay, could you give me those numbers again that you?
944 gigawatt hours 2023, 953 gigawatt hours 2024, 968 gigawatt hours 2025.
Okay.
For an average of 955 gigawatt hours per year.
Yeah, it's just taking me a little while to find it here in the,
Chair, if I may assist, it's page 958 of the 758 of the filing.
758, yeah. Still scroll into that. Hold one sec. That's 931 for 2022, 944 for 2023, 953 for 2024, 967.6 for 2025.
Mr. Blackman, are you familiar with consultants by the name of Mott MacDonald?
Yes, I am.
And this is a firm that Barbados Light and Power has engaged in the past to perform an integrated resource planning consultancy.
No, not an integrated resource plan. We've used them to do a generation expansion plan.
Okay, thank you. And are you familiar with a letter dated May the 10th, signed by your Manager of Regulatory Affairs and sent to the Fair Trading Commission? And in that letter, the Barbados Light and Power indicates that it intends to seek leave of the Commission to enter into evidence the Barbados Integrated Resource and Resilience Plan developed by the Ministry of Energy.
That's a letter dated
May the 10th, 2022. Under the hand of Adrian Carter, Manager Regulatory Affairs.
Okay, I don't remember the specifics, but it sounds correct.
And is it the company's evidence sworn in affidavits that and this was in relation to the confidentiality
Hearing?
request, yes, that the integrated resource and resilience plan, holds evidentiary value in this rate case?
Yes.
Thank you. And is Mott MacDonald also the consultant that, to your knowledge, that prepared the integrated resource and resilience plan?
Yes.
And are you aware, Mr. Blackman, of their projections, excuse me, in relation to system expansion in Barbados?
I would be aware that as part of that study, they would have had to have made some assumptions around projections.
Are you familiar with those projections? Did you participate in that integrated and resource
I did, at a high level. I mean, I wasn't at the table with them, but I would have seen the summary of the report and the findings and participated in some of the ministry's consultations on that same study.
Mm-hmm. And having asserted that that plan has evidentiary value in this hearing, can you comment on your impressions of the integrated resource and resilience plan?
So my impressions of it, of course, they would have, as you mentioned earlier, conducted similar work for us, not an integrated resource plan, but more of an expansion study. The differentiation between the two is that one, an integrated plan looks at more than just the generation needs or even the T&D needs, but takes an integrated approach to both supply side, and which would be generation, and demand side activities, which would be energy efficiency. So that study, having been done by the same consultants, many of the assumptions that were used in our study were also used in that one. However, the scope of that study was broader than the one that we would have done, because it was an integrated plan and would have gone beyond just the basic expansion needs. So I think your question was, could I comment on the outcome or the work that was done
Your
there?
impression of,
My
yes.
impression, yeah. I think it was a good body of work that had been done, good bit of stakeholder consultation, which is always an important part of studies like that. The outcome would have been similar to what we would have identified in our expansion study, which they conducted a few months previous to that
All right.
one.
So they have done projections on generation expansion and sales, expected sales. Is that correct?
Yes.
And I'm going to put their numbers to you,
Right.
Mr. Blackman. Would you agree, interpreting their projections, that they project an average sales of 1,015 gigawatt hours between 2023 to 2025, over that period?
Sorry, that doesn't sound right. In which
I'll
year?
give you the individual numbers.
Oh, okay.
The numbers are in the neighborhood of 997 gigawatt hours. This is the projections for 2023. And 1,015 gigawatt hours for 2024 and 2025.
The same in each year?
Yes.
Okay.
For an average of 1,015 gigawatt hours.
Or a little less than that if you average those three
No,
numbers.
yes.
Yeah.
I'm minded to assess those numbers, Mr. Blackman, and having had, I guess we can split the difference and call between your numbers and their numbers at 985 gigawatt hours sales on average over that 3-year period, 23, 24, 25.
What is that, the basis for that?
That's
985?
your sales projections and Mark McDonald's sales projections.
Split down the middle?
Yes.
Okay.
And an average. Would you be able, Mr. Blackman, to say what your modeling would produce as revenue, based on annual revenue, based on an average of 985 gigawatt hours per annum?
We certainly could plug a number into, any number into our models and come up with a revenue figure, but I'm not sure what the relevance would be. Maybe
The relevance would be to look at whether your projections for 2023, 24, 25, and your sales for this year would affect how you would look at your expected increase in revenue and how that would impact your rate request, Mr. Blackman. Because notwithstanding that we look at the test year, we know that the test year is an anomaly in relation to your sales.
that's correct. But we have provided a forecast, which to date has been reasonably accurate. In fact, like I mentioned, within 2%. So I'm not.
So we're
it
looking
sounds
at the
like you're
forecast,
correct.
and we're looking at
Some of which has been actualized.
yes.
Because in the forecast, we would have had to make a forecast for 2021. We actually have actuals now and are able to test the reasonableness of the forecast, and thus far, it has been very accurate, within 2%. And it appears, based on, well, we will provide the year-to-date August, but it continues to be an accurate forecast.
All right. And so if your test year, your chosen test year, has a high basic revenue compared to your 2020 revenue, would your rate increase requests go up or go down or remain the same?
Could you repeat that
We're
question?
looking at the possibility of an alternate test year because that's what is before the commission. Notwithstanding that the Barbados Light and Power asserts that they receive approval for the test year, the interveners are testing the test year. So I'm asking, if your revenue in your test year, whatever that test year is, so let's assume it's 2021, that's a full financial year. If your revenue in 2021 is higher than the anomalous revenue in 2020, would your rate increase request go up, down, or remain the same?
There are a lot of ifs in that question, so I'm just
I'll
trying to
rephrase
process
it for you. If
Yeah.
the FTC were to say we will take the 2021 as the test year,
Instead of 2020,
instead of 2020,
what would be
given
the
the
outcome?
full information that you have for 2021, would your rate request remain the same,
Okay, I understand.
go down, or increase?
I can't give an answer to that because we haven't modeled that. We actually, the process of preparing the rate case on a test year is quite involved, and it goes beyond simply the sales forecast. Because sales is one element that will affect revenue, but expenses, adjustments for known and measurable, all of those things would change. And we simply haven't done an assessment on the basis of a different test year. We did our calculations and made our submission in the application on the basis of the 2020 test year. And as is custom and practice, we provided a 5-year forecast to show what, if that 5 years pans out in the way we've assumed in relation to sales and other factors, what the level of earnings of the business would be. And so that information has been provided in the 5-year forecast.
All right, thank you, Mr. Blackman. So the 2020 sales numbers in being an aberration, I think we agree that,
I wouldn't call it an aberration.
an anomaly, it certainly is not normal. It's not a normal year. Do we agree?
Well, these days, it's hard to say what a normal year is and
Was
isn't.
2020 a normal year in relation to sales? That's all we're looking at. We're not looking at whether there were parties or
Well, I
anything
mean, we
like
had
that.
COVID,
Sales.
you have a war in Ukraine. Who
No,
knows?
Mr. Blackman. Is it a normal year in relation to
Objection,
sales?
Mr. Chairman, if I may, counsel. Again, strictly speaking, objection on the basis of the argumentative nature of the question posed. Counsel should not be arguing with the witness. He gave a response. Unless you're trying to elicit information, the question needs to be rephrased or move on, sir.
Mr.
Very
Chairman,
simple.
Mr.
She
Chairman, I
asked
want
if,
to.
may I finish, please?
Sure.
The question that was posed was whether, if it was an aberration / anomaly, it was not a normal year. The witness gave a response to that question.
Mr. Chairman, the
And may
question
I
was.
finish my objection? So I'm reading here, Mr. Chairman, the question that was actually put to the witness, and the witness gave a response. It is argumentative to continue the line if the witness has given a response to the question that was posed, sir.
Mr. Chairman, can I respond? The question actually was it a normal year in relation to sales? And the answer was not giving me the answer to that question. But Mr. Chairman, I also want to address that counsel on the other side has been tolerated by the intervener. I shouldn't say tolerated, that's a misrepresentation. They have been able to do their evidence, to present their evidence in chief without interruption. There were leading questions, there were speeches, and the intervener sat quietly and allowed them to complete their examination in chief, for which they have a considerable amount of time. They will also have the opportunity to redirect. Yet, there are constant interruptions in cross-examination of this intervener team. I noticed that there were not such in relation to other interveners, including interveners who gave extremely long speeches rather than questions. But counsel is constantly interrupting us, and I'm asking you, Mr. Chair, to do two things: to direct counsel as to the rules and the fact that we do not strictly follow the rules of evidence in this tribunal. That's one. They are seeking to apply strict rules of evidence as we follow it in court, and that's not applicable in this hearing, I would direct them to the rules if they have not looked at that themselves, but that would instruct them. And furthermore, we wish to be able to conduct our cross-examination. We respect the tribunal's ability to determine if counsel is going down the wrong road of irrelevancy or any inappropriate questioning. And we just ask to be able to conduct our cross-examination, and also for the witness to be instructed to answer a question when the question is asked.
Ms. Watson, we would allow the question, and Mr. Blackman, we are asking you to answer the question that was asked by Ms. Watson.
Could you, for my,
Could you restate the question?
Sure. Would you agree that the year 2020 was not a normal year in relation to sales?
yes, I believe I stated that earlier.
Mr. Blackman, are you able to say that the percentage difference in sales between 2020 and 2019?
Between 2020 and 2019, it was 947.7 in 2019 and 889.9 or 890 rounded off in 2020.
Can you give that in a dollar figure, that difference? So that's gigawatt hours that you are stating.
In revenue,
Yes.
okay, you'll have to give me a minute to find that as well. 1 second. I believe that is Schedule L, 5-year forecast. 1 sec. 37.
Ms. Watson,
Mr. Chairman.
I note your question had asked for it in percentage. That would require the witness to do a calculation. So could you rephrase the question to just ask for the sales in the actual sale numbers?
That's what he's looking at now, Chair.
No, but your question had asked for percentage. I just want.
Oh, I did ask him if he could give that as revenue, difference in revenue in the 2 years. That's what Mr. Blackman is addressing now. He asked it actually, revenue. I said in difference in sales, in dollar figures, and he went on to say, do you mean revenues?
Right.
And
Just, okay.
But no, you I think asked for the revenue. I'm trying to find it in the, again, that information would be somewhere in our submissions. I may need to. In 2019, in basic revenue, I believe the figure is 196.2 million. And in 2020, the test year, 186.0 million.
Are you able to give the figure for 2021?
For 2021, 1 second. I believe that figure for 2021 is 188.5 million.
Mr. Blackman, you say you believe, is
Yeah,
it?
I'm just looking here, well, just looking through the interrogatories for, it's 188.5.
Thank you. All right, Mr. Blackman, when your team, in looking at a test year, did your in-house analysis, did you realize that 2020 was an extremely abnormal year in relation to sales?
Chair, there's been no, this question has been asked, it's been answered. There's no evidence of an extremely abnormal year in relation to sales. You've just gotten figures, which shows that it's not extremely abnormal. If you have the information that you've garnered, use it. Don't put false premises to the witness.
I'll remove the word extremely, if that satisfies counsel. When, Chair, may I proceed? Mr. Blackman, when your team did its in-house analysis, did you realize that it was an abnormal year in relation to sales?
I think I've already acknowledged the anomalies in relation to sales in in the test year.
That's your personal acknowledgement. I'm asking you if your team responsible for preparing your rate case and choosing a test year, did you recognize that it was an abnormal year in relation to sales?
So you don't want my view, you want the view of the
The
persons that
process.
report to me?
Okay,
Right.
let me rewind. You have a team that prepares a rate case, is that correct?
That is correct. A team.
That team would go about selecting a test year and in the same way as you would review the component parts of your submission. Is that correct?
That is correct.
Prizes that team. Prized.
There are a number of persons that work on the submission, but the core team would be those of us who are sworn as witnesses or will appear as witnesses in this hearing, as well as Kim Griffith Tang Ho, who's our Director of Customer Solutions and overall responsibility for regulatory. But there are a number of other persons that would support at different times and so on the submissions. The core team would be those of us that are appearing here during the next few days.
And in preparing, that team working to prepare your rate case application, did that team realize that 2020 was an abnormal year in relation to sales?
That team would have, as I just indicated, recognized that sales were lower than they would have been in 2019.
Why did you not choose the nearest normal year for performance, that being 2019?
Again, I think I responded to this earlier. What are you considering normal now? Because you have figures for 2021 that are closer to 2020 than they are to 2019. You know, I don't know what you're considering the closest normal year. The criteria we use for choosing the test year is the closest year in proximity to the date of filing. Closest year with complete financials, which is 2020.
Mr. Blackman, are you finished? Sorry.
No, and from the anomalies standpoint, sales, yes, would have been lower than we saw in the previous year. But in all other regards, we considered the test year an appropriate one for submission. And again, it met the rest of all of the criteria that's required for choosing a historical test year, closest in proximity to the date of filing. Adjusted for known and measurable, and we submitted a 5-year forecast that takes into consideration or has an outlook on what the projections are likely to be in terms of earnings, and that shows clearly that there's no projection of over-earning based on the 2020 test year, if that's what you're getting at.
Not getting at anything other than the evidence. Your projections will show what you expect to occur in 2023, 2024, 2025.
That is correct.
And those numbers, we went through those already, so those
Yeah.
numbers far exceed 889 gigawatt hours, is that correct?
They exceed, I wouldn't say far exceed.
Okay, fine, we'll take out far, but they exceed. So those
That's
are
correct.
more normal numbers compared to 2019.
Again, this thing about normal, I'm not sure, so 2020 was abnormal, you're saying in terms of sales. We had COVID. 2021 would have challenges. There were abnormalities in 2021 as well. We had ashfall, we had lightning storm, we had hurricane. And like I said earlier, I'm not sure how you're categorizing normal. We're in 2022, who knows? It's becoming more difficult to forecast, but we have to provide a forecast. We do the best that we can, and we provided one in this instance that gives projections over the next 5 years.
All right, Mr. Blackman. I will come back to you later then about the credibility of your forecast. So, Mr. Blackman, looking at 2020, you're saying that your team, you can't comment on the normality, on the abnormality further than to acknowledge that it was abnormal. And if you, being aware that 2020 was an abnormal year, why did Barbados Light and Power push for a rate increase, based on what you consider to be abnormal sales figures?
I believe I would have indicated earlier and in previous testimony as to the reasons for our application. In fact, those were questions asked by your team yesterday, and I provided a response to that already. Rise in production costs, and the list goes on.
Okay, Mr. Blackman, so based on 2020's sales figures, you said that you have a dip in revenue, and because of that dip in revenue, one of the factors for coming to the rate increase, you are asking for that increase. Now that your sales are more normalized, I'm going to use that term, it has increased based on COVID restrictions being lifted, no lockdowns, etc. Now that you can see your more normalized performance, I would like your comment on the appropriateness of relying on a year in which sales was abnormal.
I think when you take the full picture into consideration, it is completely appropriate to use 2020 as a test year. And I say that in the context of the work that we've done to provide the information on 2020 and the forecast, 1 year of which has already been actualized, that we presented to demonstrate that the appropriateness of 2020 as a test year in relation to expenses and costs of the business and expected returns.
Fair enough. Let's return to your application. In the application at paragraph 119 in the general memorandum, Schedule A, you suggest, I'll give you time to pull that up.
Yeah, one sec. $119. Okay.
Right. You suggest that in 2021 was emerging to be worse than 2022. I will read. With respect to growth of electricity sales, you state This is reinforced by the company's actual sales over the period January to August 2021, which declined by 1.1% when compared to the same period 2020, suggesting that 2021 was shaping up to be different. Would you agree? To be worse than 2020?
Yeah, this was highlighting, the intent here was to highlight the level of uncertainty that we were facing in terms of doing our forecast. And you are correct. We were, based on the January to August period, we'd seen a decline relative to 2020. And so we were highlighting that point.
And did you feel, or do you feel now, because we're now some way beyond that and we can see the actuals, do you feel that in order to sell this case, you were obliged to suggest that you were going to, and are obliged to suggest that you are going to see yourself in a worse position than 2020, notwithstanding that the data shows otherwise?
No, because in our forecast, we did show a slight increase in 2021, notwithstanding that statement. So our forecast is what you should turn to in terms of what we were projecting.
And so we are all in agreement then that the Barbados Light and Power's actual performance outside of that abnormal year has improved.
No, it hasn't.
Your performance outside of 2021 has not improved in relation to sales?
In relation to sales, but sales is not the bottom line. Financial
No, we're
performance.
looking at sales.
I thought you were speaking of financial performance has deteriorated.
And we're going to come back to that, Mr. Blackman.
Okay.
Okay, Mr. Blackman, let's look at the issues related to dividend payments. Excuse me. In 2020, in 2020, the company paid no dividend to its shareholders. Is that normal?
To pay no dividend?
Yes. Normal for Barbados Light and Power.
Again, we're back to normal and abnormal. We pay dividends in some years, and some years we don't, depending on the circumstances.
What dividend did you pay in 2019?
Give me 1 second to pull that up. In 2019, 55 million.
And out of net earnings of, that was paid out of net earnings of what?
53.4 million.
What dividend did you pay in 2018?
12 million.
Out of earnings of
69.4 million.
2017?
33 million.
Out of earnings of
55.
2016? I just
mean,
want the
we
years
can
between the
provide-
last, well, you can just give me the dividend payments by year compared to earnings for the years between 2010 and 2021, given that 2022 is not a complete financial year as yet. So you can, don't look at your
Chair,
council.
if this
Chair.
is, may I suggest that if this is a filing within the application, the numbers have already been supplied and the witness can reference the page which indicates all 11, 12 years that my friend is asking. The commission has it, the witnesses have it, the information is there.
Mr. Allen, I believe the page that Mr. Blackman was presenting just now showed the information, so if he could just put back up the information, we would, this page, I think, all you need to do is to show the year.
So how far back do you want me to go?
So you just want, just,
2010,
yeah, just go back.
2010? 12 million in 2010,
from earnings of
income of 33 million,
2011,
81.9 million
in dividends,
in dividends,
from earnings of
42.1,
2012,
42
earnings,
million, 40 million,
2013,
18 million,
earnings,
43 million,
2014,
58 million, 58.8,
out of earnings of,
40.5,
and 2015,
2015 would have been the year of the self-insurance, 100 million,
out of earnings
actually
of,
2016, out of 46,
and in the year 2016,
92,
out of earnings of
137.
$137 million.
Yeah.
And from your, I want to look at reinvestment. Can you, Mr. Blackman, give this tribunal an understanding of your reinvestment policy, if there is one? If there is none, you can say that.
I'm not aware of a reinvestment policy. The company clearly reinvests. I think in my earlier remarks, I would have shared that we in this period between rate cases, have invested $774 million. And we've grown the business over that period as well. So we've made quite significant investments over that period since 2010.
All right. On average, between 2010, which is the last rate case decision, and 2021, on average, you have some figures relating to what you have invested over that period versus your earnings over that period. On average, what?
700, yeah.
Yes.
774 over that period in investments.
Yes, on average, what is your ratio of reinvestment versus your ratio of versus your dividend payouts?
The ratio of
Council, I believe that particular question would require a calculation, so could you restate the question in a different way?
All right, yes. Are you able to say what percentage of money you reinvest on average you reinvested on average between 2010 and 2021?
I can't say the figure. Perhaps one of
Mr.
the other
Jennings.
witnesses later on can give the details. But what I can tell you is we've invested $774 million over that period and grew the business by over $230 million.
All right. So and so you are suggesting that you have another witness that can better give a detailed response.
May be able to give the types of detail that you're asking for. But we've made significant investments over that period.
All right. Mr. Blackman, in relation to the steam plant retirements, kindly tell us whether the extent to which the steam plant is used and useful in providing electricity service at this time?
It is currently in service and providing electricity service.
Can you give a percentage of contribution to,
You mean the total in terms of
Yes.
kilowatt hours produced?
yes?
I couldn't say it off the top of my head, but it is in service and contributing to the overall production of electricity. It's an important part of the fleet. It provides several important characteristics of the network in terms of stability, and it is, from a fuel cost standpoint, one of our more efficient plants as well.
I note that you, are you finished? I'm
Yes,
sorry.
I am.
I note that you're saying it,
The
Are they-
steam plant,
yes.
yeah,
Isn't there S1 and an S2?
The plant consists of one unit at the moment. There were
Mm-hmm.
2 units before, but we have decommissioned one, or repurposed one as spares for the S2, which remains in service at the moment.
That means that
scheduled for
S1 is not used and useful in providing service?
No, it is providing, it
In
is used
providing
as spares.
service?
It's not producing electricity,
Mhm.
but it is providing critical spares for the unit S2 that remains in service until its scheduled retirement at the end of next year.
As the manager responsible for compliance, what is your understanding of used and useful in the provision of service?
Of used and useful,
That is correct.
my understanding of used and useful, it is still equipment that is still serving a used and useful purpose, or equipment that is still providing a benefit to the provision of electricity. And in this case, that is still providing a benefit from a spares perspective.
So to be
So
clear,
our spares are used and useful.
that,
Things in our-
so the
things in our
company's,
inventory.
the company's asset management, asset profile policy will include spare parts as used and useful in the provision of utility service. Is that what we're to understand?
I believe so. I could check, but this is equipment that is used in the operation of the business to provide electricity service.
When a part is sitting there doing nothing, is that considered to be used and useful in the provision of service? So it's not an engine, it's
It's
not a
not
steam
used,
engine.
it isn't in the provision in providing kilowatt hours, but it is a necessary part of our operation. It's a necessary part of providing that service. You can't run a plant without spares. So I'm not sure if the suggestion is that you cannot include spares, then that would seem,
Before the steam one was retired, from where did you get spares for S1 and S2?
we would purchase spares from the OEM or other sources.
And were they, so did you keep spares on site, or did you acquire spares as necessary?
Both.
So we go back to your statement that the company couldn't be expected to exist without having spares. Do you have spares for all working parts of your steam plant or any generation plant or any other generation asset constantly available to the company?
Yeah, we maintain certainly spares for all of our plants, steam and otherwise.
All right. So what year was steam one retired? Remind us.
I cannot remember the specific, I'm thinking 2018 or 2019.
Steam one having been retired in 20, you say
18 or
18 or
19,
19, it's not possible for you to give us the year.
I don't have that in information in front of me right now, but it was around that period.
All right, and so in your updated depreciation study, the company sought to include a figure of $15 million. The company in its 2019 filing schedules treated the steam plant as fully retired, fully depreciated. Is that correct?
In which year?
That is your depreciation filing, rate and policy filing in
If it's in the
2019?
depreciation filing, then that would be correct at that time.
And in your updated filing, filed in June 2020, you included $15 million for S1 and S2, is that correct?
If it is in the report, it is correct, yes.
By your evidence, the S1 was retired in possibly 2018, possibly 2019. Is that correct?
Somewhere in that time period, I believe it to be. I can confirm it, but
Could you
I
explain how the company could include $15 million for extending the life, Mr.
Chair,
Ramon? Mr. Adin, can I complete my question?
I would-
Chair, can you kindly ask counsel not to interrupt me in the middle of a question? He doesn't even know what the question is.
Chair, my friend has stated enough to indicate that the question would be better served to a depreciation expert and a financial controller who will be coming. And I was just going to indicate that it might be better served to await them to give appropriate testimony, to ask the managing director as to a sum within a depreciation schedule and its appropriateness. We have better witnesses to answer that.
Okay.
Mr. Chairman, can I continue?
I will permit the question, but the witness can indicate.
If he doesn't know, yes, he can say he doesn't
The witness can
know.
indicate if he's unaware who would be able to provide the information.
Yes, Mr. Chairman, thank you. Mr. Chairman, if you allow me to comment on council's interventions, because I have noticed that council's interventions are helpful to the witness in as much as the interventions offer a solution to the witness, and I would simply like that to stop. I would like the panel to direct council not to intervene to offer these solutions. Thank you, Mr. Chairman.
So ordered.
Thank you. And furthermore, I would like council to be
May I concern, sir, that you have just ordered me not to make an objection in
No,
the
he
form
did
I
not.
choose
No,
to?
He
Not
ordered
at
you
all,
not
not
to
at all.
direct
Not-
the witness.
Not at all.
Oh, just checking.
The order is for you to
I know
not-
my friend likes to tell witnesses the question and the answer too. Now she wants to tell me my objections and tell you what to tell me.
My
It's
objection,
getting a little
counsel,
much.
Okay, let's
my
have a little
objection,
order.
counsel, is that you are not to tell the witness the answer. That is my objection. Mr. Chair, I would also like counsel to be directed not to unnecessarily disrupt the cross-examination of his witness to be able to offer a solution. You can leave off that last part, Chair. Not to unnecessarily disrupt the cross-examination. If counsel
Continues
wants
to
to
give
come
you
over-
your directions.
Yes,
Mr.
as
Chairman,
you do.
if I may, I believe there is a solution here in terms of guiding the process forward, and this is the difficulty. There is a direct reference in the last rate hearing decision which said that in relation to the process, the rules of evidence are to be followed, and this is akin to a court of law. It is offensive, Mr. Chairman, for a counsel to indicate that appropriate objections are not to be taken and to direct to you, Mr. Chairman, the process to be followed. And I think we have to be very careful, sir. We have to be very careful in seeking to be fair to all, that we do not come down heavy-handedly on one side. It was clearly stated in the 2010 decision, sir, that the rules of evidence are to be followed, along with this being akin to a court of law. While we recognize that it is a tribunal, we must be careful into how far we go left before we end up right. We are very careful here, sir, as to what objections we take, how we take them, and how they are crafted. It is offensive, Mr. Chairman, to sit here and to hear counsel make statements about directing witnesses. Everyone who knows us, sir, knows our conduct, especially in the courts of law. And I will not, sir, I will not allow counsel, because it is within our code of ethics, what we say about what we do and how we treat each other. So I would wish that statement to be withdrawn, sir. There is no directing of witnesses, and I'm extremely want to be on the record that that type of statement is unfortunate for a counsel to make, even in a rate hearing, sir.
Chair, can I respond? council
Yes.
should, I do have a response to council's assertions about the law that applies in this tribunal, which would be useful to the tribunal as well, Mr. Chairman. Council makes reference to 2010 decision, but the decision in 2010 would simply have been the commission's statement as to what rules it would apply in that particular proceeding, but it cannot trump the law, and the law is this, Rule 17 of Utilities Regulation Procedural Rules. At a hearing, the commission may admit any evidence, including hearsay, relevant to the subject matter of the proceeding. The rules of evidence will not be applied strictly, but the commission will be cautious in assessing evidence, which is hearsay, and evidence contained in documents which have not been attested to or in which there has been no opportunity for full cross-examination. Where the commission deems evidence irrelevant or otherwise improper, that evidence will not be considered. So, notwithstanding all of council's umbrage, the rules are clear. At no conference that has occurred thus far has the commission made any statement in relation to how it will deal with evidence outside of what is specified in the rules, and the rules are law. They are embodied in a statutory instrument. Therefore, to refer to 2010 is to try to apply rules that would have been specified in 2010. Those rules have not been specified, and the commission has the authority to set the procedures that will apply. The commission has not taken that on in relation to how it will deal with evidence other than what's set out in its procedural orders, which I think, besides saying the order of evidence and the order of witnesses, the commission is silent, therefore we defer to the rules. That is what we do. All I have simply asked the commission to do is to stop council from interrupting me without any basis for doing so, to allow the interveners to be able to cross-examine the witnesses. Council can come back at the end during their re-examination that they're entitled to and re-examine their witness. That is what we are asking for, Chairman.
The Chair, I will simply say what I took umbrage was the statement which my friend has now not repeated about directing witnesses. That is the offensive statement.
Mr. Chairman, may I continue? Oh.
Okay? Please note, we are not bound by the 2010 rules. We will determine all relevant rules that will apply to this hearing. We will not direct counsel not to engage in legitimate objections, but the panel will determine what is legitimate and a reasonable objection. The Ms. Watson and Simpson team, are there several other questions, or some of your questions could be asked of some of the other witnesses at this time, so that we just want an indication of how many more questions you have for Mr. Blackman, or if some of the questions you have could be asked of some of the other witnesses?
Some of the questions can be asked of some of the other witnesses. It's somewhat difficult to say how many other questions. Mr. Chair, at this time, I actually do want to raise the issue of being able to project on our side, being able to project information to the screen. So we recognize that but I guess the witnesses who are sitting over here, or Mr. Blackman, has that capability, but we don't seem to be able to. And let me just advise what I wish to do. I think we all recognize that time is tight, and we do have some timelines that require us to serve documents beforehand. But because of those tight timelines, I myself have found it difficult to serve a particular document that I wish to put to Mr. Blackman. It's just a newspaper article, so it's quite short. And if you would give me leave to serve that electronically and then be able to project that to the screen, I just wish to ask Mr. Blackman just a couple of questions in relation to that article. That article is pertinent to investment.
Ms. Watson, we would not be able to permit you to serve that at this time, because you would need to serve all the parties, so that you can give counsel time for them to, and the witness time to prepare to answer any questions that you may pose on the information that you would be serving.
That's fine, Mr. Chairman, because there are other witnesses, and if Mr. Blackman, what I would want to suggest is that the panel permit Mr. Blackman to join a panel if the company deems it appropriate for him to be the person to answer the questions, because it really is on an issue of strategy rather than any of the niceties of finance or engineering or what have you. That's just what I would say in that regard. I will serve it today electronically.
Okay.
Can I continue?
Yes, please continue.
Thank you. Mr. Blackman, in relation to the steam plant, I would like you to comment on the impact of the aged and inefficient steam plant, or let me rephrase that. To what extent was that steam plant responsible for the 2019 blackouts?
It was not responsible for the 2019 blackouts that you referenced.
Mr. Blackman, are you familiar with the Fair Trading Commission's report on that blackout event?
I am.
And are you familiar with the Fair Trading Commission's comments in relation to the extent to which the steam plant contributed to the recovery from those blackouts?
I am not.
Are you familiar with the report, or are you not
I'm
familiar?
familiar with the report, but not the assertion that you made just now in relation to the contribution of the steam plant. Not familiar with that.
All right, Mr. Blackman. Does the company have the full report of the Fair Trading Commission on that 2019 blackout event?
We have a report from the Fair Trading Commission on the event.
The full report. So the commission
not
has
sure.
publicly published a high-level executive summary. Do you have the full report?
We do have a report on the outage. I can't say, I haven't looked to see what is on the commission's website, so I'm not sure to what you're referring, but we do have a report from the commission on the event. I don't know if that's the same that you're referring to on the website. You certainly have someone check.
Sorry, I missed the last part of what you said. You're not sure?
We do have a report on the outage from the Fair Trading Commission. I'm not sure to what you're referring on the website.
Oh, no,
Ours
I
didn't come
say
from the
anything.
website.
I
Ours
didn't
came
say
from-
anything about the website. I said they've published something. And I'm just
Well,
asking you if
I
you're aware
I assumed
of...
when you said published, it was on the website.
No,
Oh,
published just means that it's out there.
Okay.
And so you have the full report. That's what I'm trying to understand.
I have a report that we received from the FTC. I believe it to be a full report.
Mr. Chairman, in our interrogatories, we requested the report. Can we again request that the report be provided to interveners? We think it is pertinent to the issue of prudence and accountability.
The commission will provide a redacted copy of the report to the interveners.
Thank you, Chairman. Okay, Mr. Chairman. Sorry, Mr. Blackman. Allow me to read you since you say you have the report, allow me to read you a provision, an excerpt from that report. So this is from the executive summary, the commission's findings in relation to that outage. Generation adequacy. That is at page 22 of the Fair Trading Commission's report. But before I read that, can I confirm that the Barbados Light and Power submitted a report on the island-wide outage of November 18th and 19th, 2019?
To the Fair Trading Commission?
Yes.
Yes.
Mr. Chairman, can we also request a copy of the Barbados Light and Power's report on the outage, the 2019 outage, that which fed into the Fair Trading Commission's report? It can be redacted if necessary, but can we also request a copy of that report?
Yes, we would ask that they submit a redacted copy of.
Okay, Chair. Yeah.
Thank you. Right, let me read from that report. An adequate supply of power refers to the ability of the electric system to supply the aggregate electrical demand and energy requirements of customers at all times, taking into account scheduled and reasonably unscheduled outages of the power system elements. The BLPC did not have sufficient plant capacity above the expected peak load that could have addressed contingencies on November 18th and 19th, 2019. A total of 18.4 megawatts and 3.1 megawatt respectively were available prior to the outages. Adequate plant capacity takes into account the estimated peak load, forced outage of the largest unit, and the aggregate capacity of units undergoing planned maintenance. The Commission's computation of the reserve margin based on the dependable and certain capacities for generating units, revealed that 32%, the 32% threshold was not maintained. Were you able to follow?
Yes.
All right. I'm just going to ask you a couple of questions on that. Kindly advise the commission what the largest unit is that is referred to in that comment of the commission. Forced outage of the largest unit. Adequate plant capacity takes into account the estimated peak load, forced outage of the largest unit, and the adequate capacity of units undergoing planned maintenance. What was the largest unit referred to?
Our largest unit is would be a low-speed diesel B unit, which is around 30 megawatts,
And
27 MCR.
at the time, what units were undergoing planned maintenance?
But you're reading from the report, and you've requested information which will be shared that will give those details. There were some units out for maintenance, but we also during that period experienced some very unusual circumstances, particularly around fuel, which you'll see in the report. We were receiving fuel at the time that created a problem for many of our plants that burnt that type of fuel, heavy fuel oil. And as a result, that resulted in far more than what would normally be the case in terms of units out of service. We would normally have units out for maintenance. What I would say is that, again, very unusual circumstances that led to that event. There was a full and complete investigation done. That information you requested and I expect will be shared with you. And coming out of it, there were a number of actions that we agreed to take based on the FTC's final report. There were 24, I believe, and we've done 22. And 2 are in progress and should be completed shortly to complete the full list of actions that were agreed to be taken at that time. Have other witnesses coming behind that would have been involved intimately with the investigation. But like I say, from our perspective, we've gone through the process. We accepted the commission's findings and decisions. There are some areas that we didn't fully agree with. However, we've accepted it. We've accepted the actions to be taken. We've implemented almost all. There are a couple still that are in progress and will be completed shortly. Beyond that, any details that you were seeking would be available in the reports.
Okay, Mr. Blackman, at what time did the company become aware of this fuel problem? Did it become aware at the time of the outage, or was the company aware before?
Again, those details, specific details, would be in the reports that you've requested.
Are you saying, Mr. Blackman, that you are not aware?
No, I'm saying that I can't give specific dates. I don't have the report in my head or in front of me, and that type of information would have been provided at the time. We were experiencing problems with fuel, both in terms of supply and quality.
For how long had you been experiencing those problems with fuel? That's the question. You don't have to give an exact date. You can say 2 months, 10 months. For how long?
That information would be in the report. Like I said, the details. Sorry.
Okay. Intervener Watson, I do appreciate that you would respect that Mr. Blackman, as Managing Director of Barbados Light and Power, should be able to answer certain questions, but they have identified Rohan Seal and Johan Graves as a witness panel to speak to some of these issues. So could we...
Sure, Mr. Chairman. I just, not to interrupt you, but I want to explain why I'm asking Mr. Blackman. Mr. Blackman and I both were involved in the recovery meeting, so I'm aware that Mr. Blackman is aware of what occurred at the time.
No, we have an intervener giving evidence.
I am giving an explanation to the
what
chairman.
Mr. Blackman knows.
I'm not saying what he knows. I'm saying I'm aware.
Please,
Mr. Chairman, I'm simply explaining to you that I am aware of Mr. Blackman's involvement at the time that the issue occurred. So I expect that he is aware, as the CEO, because he's the CEO, what occurred from his staff, and he would be able to give evidence in relation to that.
But
If we're saying that he wouldn't, then that's fine. I will accept that.
So he has indicated that he cannot recall all of the information that would be helpful to us in making a determination, and that he would provide the report. And we're just asking that after the report have been received, where you could obtain all of the relevant information, you will then have the opportunity to question further the witness panel that the Barbados Light and Power will present in terms of Rohan Seal and Johan Graves, in terms of all those questions pertaining to generation adequacy.
In relation to that, Mr. Chair, because the procedural rules are unclear, would interveners be in a position to request that a witness be recalled to give evidence on any particular issue? Particularly since we're looking at panels. So I'm asking a procedural matter since this has come up. I wouldn't want that one of the other witnesses say that it's not within their capacity to answer because it may be a strategic matter or a matter that falls within Mr. Blackman in particular, because he has this wide responsibility.
We will not make that determination at this time, but in the event that the case arises, we would hear the reason, and we will hear the application at that time, and we will make a determination.
Chair, if I may, just an indication at this time. There's been a request for these reports in relation to the issue of prudence and accountability, both of which I believe are within the domain of Intervenor Watson to assess in terms of making the assessment and is relevant before this commission. Please note, however, that we on this side do not accept that there will be any re-litigation or rehearing of the 2019 incident. And if on the delivery of these reports, in terms of the matters that we see, I am indicating to the commission, because my objections can rile, I will be ensuring that the relevance as to what is done on the procedural list is maintained. And I just wish to indicate that now, a lot of documents have been requested. There is no place for re-litigation of matters that have already been heard and assessed and ruled on by this commission. Thank you.
Mr. Chair, am I permitted to comment on that? There was no litigation of 2019 by anybody in this room, so I do not know what council is speaking about. The company's performance from 2010 to now, in fact throughout history, is subject to review in relation to whether they have acted prudently, whether they have complied with their obligation to provide service as a utility, a licensed utility in this country. Those are relevant issues, and for council to suggest that there should be a cap on those relevant issues, notwithstanding that there's an issues list, but I think we can understand that as we go along, there may be other issues that arise, and the commission will rule as it deems fit whether they're relevant or not. But to suggest that an outage that has been described in the strongest of terms and that had serious impacts on Barbados, an outage involving the company's operations and equipment that right now is at question, Chair, because we're looking at the company trying to say the steam plant continues to be relevant. Therefore, I find it to be a very dangerous suggestion to suggest that we on the intervener side or the commission cannot examine the company's performance in relation to that 2019 outage, which then caused a week's outage with another utility provider in Barbados. That is an absurdity and frankly an insult to our intelligence. It is also an insult to the people of Barbados, might I add.
I feel it important to correct something you just said. That plant did not cause any outage. So I don't know where you're getting that from and why you keep repeating it.
Correct me, Mr. Blackman, we'll come to that, rest
That's
assured.
fine, but I did correct you.
You're wrong to correct me, and I'm just saying to you that you should rest assured we
Counsel.
are going to come to that.
Intervenor Watson, could you
Yes, Mr. Chairman.
continue your cross-examination? But bear in mind that we did request that if there are things that the other members of the Barbados Light and Power Witness panel would be in a better position to answer, that you defer such questions to that individual and try to see if we could get back to the questions that Mr. Blackman would be able to answer.
Thank you, Mr. Chairman. It's just my opinion that he can answer these questions. Mr. Chairman, I also want to clarify something for the record. On the 4th of January, 2022, we requested the said same reports in our letter of intervention. We have not received them, so we're forced to ask for them again today. Had we received those reports, we would be able to put those details to Mr. Blackman. It is therefore prejudicial to us to not have provided them and then to suggest to us that we cannot bring Mr. Blackman back to answer those. We should have had those reports. All of the interveners would have, had they been provided in accordance with our information requests and interrogatories, which as a matter of law, the company is obligated to answer and respond to, and they simply have not. May I continue, Mr. Chairman, with my questions?
Chair, I just believe it should be noted that the commission never ruled that no one would be brought back. They ruled that they will make the assessment at the appropriate time. And this seems to be a habit that is being continued. I just want that noted.
May I continue, Mr. Chairman?
Could you continue?
Thank you. Mr. Blackman, are you familiar with the Fair Trading Commission's decision on the fuel clause adjustment, their fuel clause adjustment review that was conducted in 2013?
Yes, I am.
I'm sorry, Mr. Chairman, just give me a minute. I am scrolling through far too many screens, I think. Let me just find. Just give me a moment, please. Yes. Are you aware of the Commission's finding, the Commission's recommendation in that, let me just give the full title of that report for the Commission's information. That is the Fuel Clause Adjustment Findings Report, dated April 19th, 2013. Mr. Blackman, you have said, all right, let me not repeat what you have said. Are you aware of the Commission's recommendation contained in that report? I will read it to you. That states, the Commission is of the view that based on the information available, the risks associated with the suggested change in dispatch outweigh any potential reduction in fuel costs. It is also recognized that the steam turbine generators, which were installed in 1976 and scheduled for retirement in 2012, were retrofitted to temporarily extend their useful life. The Commission is therefore of the view that as a priority, the BLPC should replace the steam turbine generators with more efficient generating plant in order to reduce fuel costs and the associated FCA. Are you aware of that recommendation?
Yes, I am.
The company's response to that recommendation, did you replace the steam plant?
We haven't replaced it yet, no.
And in 2013, why did you not respond to that recommendation?
We would have responded. As I had indicated earlier, we continuously assess the market and conditions and make prudent decisions on whether to extend the life of a plant or to retire it and replace it with other capacity, or for that matter, to purchase capacity from an independent power producer. Those are all options. However, in that period, as I had indicated previously, there were a number of circumstances that we could not ignore. And those included the fact that sales did not manifest in the way they were being projected at the time. In fact, sales in the last rate case were projected to be 4%. Our investment plan or forecast and expansion plans were based in the 2009 rate case on a 4% base case growth. Our sales, in fact, have been flat, actually negative if you count the test year 2020 and 2021 for that matter. And so what we were looking at and basing expansion plans on in 2009 would have been on the basis of sales that would be almost double what they are today when you compound sales over that period. In 2012, closer to the time, probably in parallel with the report that you're referring to, we would have been doing the first IRP, which the company led back then, 2012 to 2014. And at that time, we did revise the sales down because the signs were there already that sales weren't materializing as anticipated in the rate case. And I believe our sales forecast then in the base case, and we always run 7 sensitivities, would have been for under 2%, 1.5%, 1.35%, I think was the figure at the time. So sales would have been a circumstance. So we did have the findings of the FCA report. And we did have things going on the ground at the time that we needed to take into consideration. And having taken all those, sales being one, the market restructuring that was in progress at the time being another, the calls by policymakers to shift away from fossil fuel to renewables being another factor, all of those would have influenced the decision that we made to reinvest in the extension of that plant, rather than build something that potentially would become or could become stranded and be something else that we need to ask our customers to pay for, in addition to whatever renewables came on stream, like the 60 megawatts of waste to energy and biomass plant that was indicated would be coming online in that same period when these studies that you're referring to were being done. So those were the circumstances within which we made the decisions that we made at the time, and they were prudent decisions on the basis of all that I've just described.
Let me read again from that report. The BLMP submitted its integrated resource plan on March 28, 2013 for approval of the Commission. The IRP, among other things, makes recommendations for the retirement of the 2 steam turbines, the construction of new generating plant, the use of renewable energy options, and energy efficiency measures. The Commission is reviewing the detailed IRP.
It was reviewing the detailed IRP.
Yes, that's not the question.
But that's an important point, though.
That's all right. Kindly comment on the retirement recommendations contained, the recommendations for retirement of the steam plant contained in the IRP. And you can comment on the updated, because I know what's in it. So you can make comments on the updated IRP. Because yes, go ahead.
Sure. As I indicated a short while ago, there are a number of factors that would have influenced the decision that we made. And those included the fact that sales was not materializing in the way they were. Fossil fuel and the building of fossil fuel was frowned upon by many. And in fact, even up to the point where we were about to sign a contract for the Clean Energy Bridge in 2019, we were still receiving signals at the time from important stakeholders and that fossil fuel was not, we're not convinced fossil fuel is the direction and the way we should go. So in an environment like that, from an investment standpoint, faced with those challenges that we had at the time, a move away and a strong move away from fossil fuel, adoption of 100% by 2030 goals for clean energy, sales that weren't materializing, notices for plants that, in hindsight, yes, did not come, but had they come, would have made a significant difference. In fact, those plants, that 60 megawatt, we have just installed 33, and we are going to retire the steam and a gas turbine on the basis of 33 megawatts of new capacity added. So you could imagine if the 60 that didn't materialize had come about, where would we be today? That would be capacity that would not have been needed. It would be stranded, in fact, and we would be here asking the commission and ratepayers to pay for that plant, in addition to that 60 megawatts that we would have been paying a power purchase agreement price on. And that would not be reasonable, it would not be prudent. Those are the circumstances around the decisions made at that time.
Can you confirm that in your integrated resource plan updated at the request of the Fair Trading Commission, that that the company made, or the company indicated that it would retire the steam plant in all scenarios, that's all sales scenarios and all fuel scenarios, by 2016? You can say yes or
That
no.
may be the recommendation in the RP, but it's not a static. These things are not static. We're not in an environment where things don't change and circumstances were changing all the time, especially in our environment. This is a rapidly transitioning market.
All
I
right.
mentioned earlier that we are in the top tier in the world in terms of renewable penetration. So things are changing rapidly, and we need to be constantly assessing and reassessing. And yes, you could look at a report and read things from specific reports. If you go over that 10 years, you'll see a lot has changed since then.
In which case, Mr. Blackman, should we come to the conclusion that we can ignore those reports because things are so rapidly changing?
No.
All of your recommendations and forecasts we can just set aside and just rely on past performance?
Of course not. But I'm saying that you don't rely slavishly on a report that's done in 2013, in 2020. But that wouldn't make any sense.
Wait, I'm not talking about 2020, I'm talking about why you didn't make, I'm talking about not retiring the steam plant and installing the new plant in 2016.
But
So
I've explained exactly why we didn't do that.
no, your
By
explanation is Cahill. Your explanation is the base. And Mr. Chairman, if I may, because the dates are important.
Objection,
Yeah, but
argumentative,
I-
Mr.
The dates are important, Mr. Chairman, if you just permit me.
Mr.
Because
Chairman, I'm
I
objecting
accept-
to the argumentative line of question.
I'm talking
and
to the chairman
I
of the
am
council.
making an objection.
Mr. Chairman, we were speaking. Can council then be allowed to interrupt our discussion where I'm trying to explain myself to the panel and say I'm making an objection? I don't know what he's objecting to because I am making an explanation to you, Mr. Chairman.
Yes, Mr. Chairman, I indicated that there was an argumentative line of questioning. I would repeat the objection. You are not allowed to badger a witness who has given a response to your question. It went down an argumentative line. I think that is what prompted the chairman at the same time to wish to make a statement. So I would defer to the chairman in this regard, sir.
Mr. Chairman, may I continue my explanation to you? If you'll permit me, Mr. Chairman, we have an evidence from the company that they made certain decisions based on the indication that the government would bring in 60 megawatts based on the waste-to-energy plant. And there's a point in time at which that would no longer be relevant. I think that point in time and the timing of the proposed requirements contained in the IRP are relevant to making a determination as to the prudence of the non-retirement of the steam plant, because it's still not retired except for the spares part. Can I continue to speak to the witness about what happened between 2010 and now, or let's say 2012, because that's when it was supposed to be put in, 2012 and now in relation to the steam plant, because it is important.
Yes, but Intervenor Watson, the witness did indicate that there were certain conditions prevailing over the last couple of years that would have caused the company to rethink their approach to how they would have dealt with the steam plant and things like this. So I think you had given enough in evidence. So unless there's a direct question, I would like you to move on, because I think the applicant, or Mr. Blackman, did answer some of the question in relation to why this was not done. So could we move along, please?
Lady Chairman. Mr. Blackman, you have indicated to this forum that in 2012, again in 2014, I presume if we're looking at Cahill, 2016, 2019, based on interventions from other parties, fossil fuel investment was frowned upon, and the company made a decision not to retire the steam plant and install and commission new fossil fuel plant as a result of those occurrences between 2010 and 2019. Is that correct?
You're paraphrasing, I guess. I didn't say exactly what you said there. What I did indicate is that the trend away from fossil fuel and the policy discussions about investing in renewables and transitioning to a renewable energy future had begun as far back as 2010, for that matter. And coupled with that would have been circumstances like sales. The sales that we identified in the IRP did not materialize either. We had negative sales, even before counting in the anomalous sales in 2020. Up to 2019, our sales were slightly negative. In all of those previous studies, it assumed positive sales. That never materialized. That is a circumstance that cannot be ignored, and it would be silly of us to make plans on the basis of sales that aren't materializing or happening.
Thank you, Mr. Blackman. My question to you is, if it was imprudent between 2010 and 2020 to retire the steam plant and install 33 megawatts or 32 megawatts of medium speed diesel generating plant because of fossil fuel becoming frowned upon,
Yeah.
planned renewable energy investments, the 2030 100%,
100 vision. Yeah.
and low sales, how is it after your sales performance in 2020 and after we've moved even closer to 2030, and so moving to renewables in 2030, how is it now prudent to invest in 33 megawatts of fossil fuel generating plant?
So it's 2019 when we would have signed the contract for the plant. We would have had clear signals from government. Some of it was very public. People saw that notwithstanding the push to renewable energy, we need to move quickly and get some immediate energy on the ground, some fossil fuel plant in that we had been planning for a long time. Because since 2010, we had started to put plans in place. We actually put the town planning application as far back as 2010. We got approval, final approval, conditional in 2019, which allowed us to move forward. But it was not an easy undertaking. There were concerns that policymakers had been making in relation to moving forward fossil fuel. And internally, we had our concerns, which I will admit, because the conditions were changing. We entered into new licensing discussions and negotiations. Sales.
Chairman, kindly direct the witness to not refer to licenses.
Licenses, please.
You cannot tell the witness not to reference a circumstance which was involved in his assessment. I have sat quietly as persons seem to fail to make the distinction between evidence as to what is in a document and the existence of the document. The document existed. Mr. Blackman is indicating it was a contemplation. He has not said what was in it. He said this document made me reconsider certain things. You cannot tell the witness he cannot reference it. He's not relying on it for the purposes of any application that is before the Trading Commission. A question was asked and the witness is answering. There's no ruling in here that the word draft license cannot be issued.
Mr. Chairman, the Commission's direction, based on its confidentiality decision, is that the draft licenses are not relevant. Therefore, and that is the assertion of the company. So how can the company now seek to rely on draft licenses being in existence to justify any of its actions? It's simply not relevant.
The witness is not relying on the draft licenses, sorry. So, but We still have,
Chair, I don't have a lot of questions. I just would like some clarity. The commission's decision in the confidentiality matter, I do want to explore this, I think it's important. The commission's decision in the confidentiality matter is that the draft licenses are not relevant and that references to the draft licenses should be removed from the application. That is
There was no such ruling.
Yes,
Chair,
there
that
was.
should
That
be
is
removed
the
from the application.
that is the determination
There was no-
stated
the-
very clearly
Ms.
at
Watson.
paragraph 45 of the determination of the decision. It's there in plain English.
okay. We're simply saying that we will not take the draft licenses into consideration in making any determination, but it does not mean that the witness could not indicate that he considered it. We will determine what is appropriate at the time of making our determination. So
So,
if we can
Chair,
just,
counsel interrupted me. I would like to continue to say what I was saying
Okay.
so that you can give me the clarity that I am seeking. The company's communication to the Fair Trading Commission is that licenses are not relevant to this. Let me just finish, Chair, if you would let me finish. Because
You know-
it was a discussion that had gone on for some time prior to the actual confidentiality hearing. And the company's assertion was that they could remove them because the licenses were not relevant. I do not think that, let me continue, Chair. I do not think that they were just saying the pieces of paper were not relevant because they have content. And I'm not questioning him on the content. I accept that those are out. I'm not questioning him on it. That's not a matter for this tribunal. But if the company is saying that the draft licenses as a concept are not relevant, that's what I'm trying to understand. What exactly are they saying is not relevant? The actual details of the draft licenses, or the fact that draft licenses exist, or the fact that they're in license negotiations? That is unclear to this side, and we need it to be made clear because the company is seeking to rely on draft licenses to justify certain things, but at the same time saying that they are not relevant. And I think we all have to make a distinction between what is in them and the fact that they're saying because licenses have been brought to us and we're discussing them and we're agreeing, we want to use that change in our circumstances to justify certain things. So they're either relevant or they are not.
Ms. Watson, could you allow the witness to just answer the question, and we note that it is approaching or after 11 and we would like you to wrap up. So Mr. Blackman, could you just answer the question? And
But I think I did. I mean, so I mentioned the factors. We want to call it a franchise. Our franchise was expiring in 2028, and discussions around extension or a new arrangement for the franchise beyond 2028. Those discussions had started as far back, actually well back, even before 2019, because the investments we make are long-term, 25, 30, sometimes longer, as we're well aware. And with the franchise expiring there, from a utility perspective, investor standpoint, you need to understand what the direction is, where are you going, what happens beyond the franchise date, because we are in the business with long life assets. And so that was a factor. Expiring franchise, sales in not materializing as forecast, either in the rate case in 2010 or 2009, I keep saying 2009 rate case, or in our own studies, the one that informed 2009, the IRP study. So those were all factors, and then multiple projects that had been identified by third parties, not the utility, to be coming on stream. Couldn't ignore that capacity. It takes a while to build a plant. When we started in 2019, yes, we had the delays from COVID, but that plant just commissioned this year. We started plans for this plant as far back as 2010, as I mentioned, in terms of town planning application. It takes a little while. The reason we were able to move as quickly as we did in 2019 when everyone was in alignment is because we had done significant groundwork. We were able to sign a contract.
Mr. Chairman, I think the witness has said a lot of this before. I want to, finish. I want to move on to my next
allow
question.
the witness to continue.
Thank you, Chair.
Mr. Chairman is in evidence already. I don't think that Mr. Blackman wants to repeat
Please
himself.
allow the witness to continue.
Continue, Mr. Blackman.
Thank you. So no, I think I'll end on that point.
Mr.
Circumstances
Blackman,
changed, and we,
Mr. Blackman, what changed the investment, the retirement of the steam plant and the investment in the 33 megawatts from imprudent to prudent? What factor?
the factors that changed would have been the circumstances at the time. We had all policymakers and almost all stakeholders in alignment that we needed additional fossil fuel generation, if not at least in the short term. That was a significant factor and a significant change, because that had not been the case prior to us making that decision in late 2019. And as a result of that, we were able to move forward very quickly. We were able to get permissions to build the plant, or conditional approvals that, like I say, we had been working on for years to build that plant. And we were able to move forward by signing a contract and having it constructed and in service. Those were some of the factors that would have changed. Certainly the level of alignment and support for moving forward with an investment like that. Additionally, we had started to make progress in relation to the discussion on the franchise and what happens beyond.
Mr. Chairman, can I interrupt here? Because that is a euphemism for draft licenses.
Oh, my
And
goodness.
I think
can't say
we have to,
franchise.
we have to not
Miss-
go there, Mr.
Miss-
Chairman. It's like the draft license issue is either part of this
No,
hearing or it
no.
is not.
The
The
franchise.
the expiry of the
stop being
franchise is what
argumentative
triggers
with
draft
the-
license. Mr.
with-
Chair, I'm
but-
not being argumentative.
with-
You
with-
made a ruling
with-
yesterday, Mr. Chairman,
But I'm not
about the
referring to-
draft
Miss-
licenses. And now we're getting around that ruling by referring to the ending of the franchise, but it's 6.5 dozen. It's the same thing.
No, it
Ms.
isn't, because
Watson.
you don't have to have a license
You're
beyond the
quite
franchise.
right.
Miss-
And if we're going to suggest
Miss-
that the
Miss
franchise is
Watson.
ending, that has an impact on whether you get rates or not also. Yes, Mr. Chairman, I'm sorry, I apologize.
Yes.
Chairman, could you kindly ask council to stop with the sidebar as well?
I would also like that you allow the witness to make
Mr.
a
Ch-
statement.
Yes, Mr. Chairman.
And please do
I
not
accept.
interrupt the witness when he's presenting his
I
evidence.
accept that. I do, however, want to draw to the panel's attention that a reference to the end of the franchise does tangentially relate to
It's
the
not-
issue, because he's
But
talking
that-
about,
but-
he's
but
talking about
we've
discussions,
just
Chairman.
asked you to allow the witness to continue giving his evidence or his statements. We will determine
You will
what is
determine whether it's
appropriate
relevant or not.
not.
Thank you, Mr. Chairman. Continue, Mr. Blackman. You're answering the question.
Those were those were
The
some of the key
factors.
factors. I'm not saying that is it exclusively, but those come immediately to mind as key factors and changes over that period. We did start the discussions. Things have started to move in a different direction. There was a greater level of alignment, certainly. We got a conditional approval. Of course, you wouldn't move forward with a $130+ million investment without that. That wouldn't be prudent.
Are you finished?
I am.
Is it your evidence that the government signaled to you in 2019 that you should move ahead with this fossil fuel plant?
Yes, we did get that signal.
Is it your evidence that the government signaled to you in 2013 or 14 when they were contemplating the waste-to-energy plant that you should not invest
No.
in the, okay. Thank you, Mr. Blackman.
Thank you, Mr. Watson.
Okay. So,
Finished with Mr. Blackman for now, Mr. Chairman.
not, okay, we'll take a 20-minute recess and at this time.
the commission since 20 in that decision that is going to replace the steam plant in order to implement new generation plant, medium steel diesel plant, that will save the consumers $30 million.
So that is the question that we would
So
like
the
you to...
question that I want to be sure is that Mr. On the oath to let us know if that was the position then.
And my answer to the question, I think I answered it already, is that the rates and the determination made in 2010 was not on the basis of any investment plan. It was on the basis of the company's financial performance in a historical test year, 2008. So plans in relation to steam or otherwise are really not relevant here because the decision is based on a 2008 test year in which the steam plant is running.
Mr. Chairman, I'd like you to allow the witness to let me present the evidence here, because this is exactly stuff that we've presented the company over and over. And this could be very simple.
Okay. Has this evidence been entered?
This is, I'm trying to, because the timeline and the commercial aspects are key.
The question I'm asking is if the evidence that you want to rely on, have it been served on all parties? Have that evidence you...
Yes, the letter of intervention would have included the information, so that would have been on all parties. If I can go back to my opening statement, I can sort of refer that for you. But this part of it, because this is the easy part, I didn't expect that this part to be so hard at all.
It isn't.
No. Let me go at this again. I really want us to get this right because the timeline is extremely critical. My predecessor, Ms. Watson, did mention the timeline, but I didn't think that was really, we didn't get to the bottom of it. The timeline is critical of this here. So let me go back at this. I want to make sure that everybody's aware of what we're submitting. There was no challenge by Lighting Power at all on this. If I go back to my letter of intervention, and we looked at, and you got to give me some time to scroll through. All right, so.
While you're doing that, could you give me the date of the letter?
My letter of intervention was on the 5th of January, 2022.
We didn't have any letters of intervention in January.
This is the letter of intervention I sent to the Fair Trading Commission.
Oh, right.
Now, in that decision, it says, right?
What decision?
This is in my letter of intervention, I'm quoting from, it says here, the BLPC recognizes that Barbados still has a lot to do with the cheap.
What are you quoting from, Mr. Lane?
I'm quoting from my letter of intervention that I sent to the Commission on the 5th of January, and I'll give you the end of the references for every statement that's going to be made, because I didn't think, and I should have, but I didn't think that we would have been, this was the easy part. This really was the easy part. I am surprised even in asking myself, how could this happen to me? Because this is plain saying what Lighting Power says in its own application. But we're going to get through this. You don't worry. Don't worry at all. At page 10, in its application, BLPC recognizes that Barbados still has a lot to do to achieve its 2030 targets, and this is in relation to the same clean energy bridge as well, but it wants to replace it with this agent and efficient plant. That was that is 2010. That was in its one application. Now, prior to that, BLPC
the Light and Power Company had said that just give me a few minutes. Right. During the 2010 rate case, BLPC did commit to retiring its steam turbine plants that were installed in 1976. The units were to be retired in 2012, and almost a decade later, these are still in service even today. This was in my letter of intervention that was served on all parties, and that was a statement made after page 120.120 paragraph, and in 119 paragraph it said, Leiden Paul said, the Leiden Paul in its end of life estimation of the units, the 10 and 11 were installed in 1981, the 12 were in 1987, and the turn was 1990. And these units were all scheduled to be retired in 2018, and I'm going to be coming back to that, but in a different aspect. But I'm trying to establish that the company had agreed that it had to place an order for the new equipment immediately, that's at the end of 2009, in order to replace the steam plant by 2012. And there's enough correspondence and interrogatories and everything around that to establish that fact, because the timeline is important. Mr. Blackman, are you still not clear that the company did agree that it was going to replace the steam plants with a new medium-speed diesel plant that would save the country $30 million per year?
Yeah, I can't agree with the question as stated, because the company, I think you're referencing a commitment, which is not the word I would use. The company, as is required when you file a rate application, has to provide some indication of what its investment plans and what its forecasted requirements would be. And that was done. And it did include, yes, new plant and projections for retirements of steam and other units for that matter, which we, over the period, as I indicated earlier, it's our responsibility as a utility and every responsible utility to continually reassess the requirements in light of prevailing conditions and circumstances and market conditions, and that is what we did subsequent to the last rate case. Notwithstanding, as I mentioned earlier, we still, I think you talked about orders, but what we would have done, like again, any responsible utility, is to put development plans in place, so start the work of development so that you aren't found flat-footed when eventually you do need to pull the trigger on a particular investment. And that started in 2010.
But Mr. Blackman, you yourself said in testimony today that in 2010 you started to get seek town and country planning permission,
Yes.
to be able to get the medium steel diesel plant, and that was intended to replace the same steam plant, which would have been going into service in 2012.
That's the development plans that I mentioned just now. We would have started the development work, which includes town planning. I mean, anyone that goes through a process like that knows that you don't wait until the day that you need something to start the process. So we would have gone through a process, started it. I also mentioned today that we got approval, conditional approval from town planning for that plant in 2019. If you're referring to the Clean Energy Bridge.
Mr. Chairman, if you will, allow me to put confirmation that in the hearing of 2009, that Leighton Paul did a commitment, and I'll extract the exact words, that information that states that the company committed to replace the steam plant, right, and had to be ordered by 2009 for it to be installed by 2012. And we have had enough discussion around this that I didn't expect. That's the easy part. So I didn't even expect that we could start it, but we will continue. So on the basis that the steam plant would have been be ready by 2012. And that plan, part of that testimony was on the basis that it will, one, it would use less costly fuel, and it was also said at the time that the Clean Energy Bridge has the ability, the medium speed diesel has the ability to migrate and use even from, to be able to use gas if and when it becomes available. So let's look at that again. In its decision in 2010, it says the commission accepts that
Mr. Vent, I keep asking you to refer to information that is actually before the commission and not to refer to a 2010 decision.
Let's hold it there, Mr. Chairman. What we're going to do, all the information that we want to support this evidence here with will be given, because it's all there already. You don't worry at all. The issue for me is that the dates are critical in this decision, and I'll tell you why. Haven't had a commitment from, you can't just come to the commission and say one thing and then do something else without giving a reason why. So we had a situation where for all the information provided, that the plant was planned to replace those steam plants in the end of 2009 in order to save the customers of the country about $30 million. Now I want to go on from there. So,
Chair,
like,
if my friend may allow me, I understand the difference of fact basis in terms of his premise and the answer that's being received from the witness. But if I could suggest that he asks questions as opposed to giving testimony of what he understood, we might be able to get to where he wants Mr. Blackman to get to.
Chairman, unless you insist, you could rest assured that I'm not leaving here till we get to the bottom of this. We cannot have a situation where there's a commitment to save ratepayers $30 million and the country $30 million in foreign exchange, and we don't get the bottom of this.
But Mr. Vent, what is the question? Would like Mr. Blackman to answer. So you cannot testify at the same time that you are examining a witness. So ask Mr. Blackman a question.
Just give me a minute, Mr. Chairman. So, Mr. Chairman, I'm establishing the fact that BLP requested the company in 2009 that it would save $30 million, and it stated, we estimate it would have saved around $30 million per year at an oil price of $60 per barrel in fuel by being able to install the new equipment, which will use not only fuel, but less costly fuel. And that was the position that the company gave in its decision of 2010, and I think that was around page 24, point number 62. So I'm saying that we have to start from there because the timeline is critical. So my questions then will continue from here. My question is, on the basis of that information, I'm saying that the company did not order equipment at the end of 2009, or let me ask you, Did the company order equipment, Mr. Blackman, at the end of 2009?
Yes, we did order equipment.
Did the equipment to replace the steam plant?
No, we didn't order equipment.
Did we order equipment to replace the steam plant in January of 2010?
No, we did not.
Did we order it in June of 2010?
No,
Did we order it in December of 2010?
no,
Did we order it in January of 2011?
no.
Miss,
No, please, Mr. Chairman,
No, no,
please.
no, no,
The
no, no,
timeline is critical for us. I would like, with the greatest respect, to allow me to present this testimony because the timeline is critical. If there's one thing you
and
do
our
for me,
timing
Mr.
is
Chairman.
also critical, and we would like you to get to a specific
Mr.
question, because
Mr.
just
Chairman,
asking
I'm
him
ask-
January, February, March,
But I'm
April, May,
asking because I
June.
told you how critical it is, and you've got to trust me on this. I'm asking, Mr. Chairman, if this equipment was ordered in June of 2011.
Just ask when it was ordered.
Oh, my goodness. Has this equipment been ordered in June 2011?
No, Mr. Wang.
And finally, has it been ordered at the end of 2011?
No,
Right. So here's it we have established. This equipment that was to be ordered in 2009 was not ordered in January of 2010, nor June of 2010, and this is all the time that the company has to order this equipment, or 2011, which would have meant that if you order in 2009, the equipment is installed in 2012, and if you order it in 2010, the equipment installed in 2013, and if you order it in 2011, the equipment would be ordered, would be available and ready for 2014. So the point being, that's why I tell the dates are so critical. Now at that time now, Mr. Chairman, I'm directing questions again now to you. So we've established that once those equipment, we could not have had them in 2013, nor in 2014. So what are the reasons given for not ordering the new medium speed diesel units in 2009 to replace the old inefficient plant by 2012? One of the reasons that I've heard you say, and please correct me, Mr. Blackman, is it one of the reasons that you're saying that it was in part guided by the recession which began in 2009?
it was in part guided by fall off in sales, which may...
No, you just give me one time. I can go all for you. You have to rest assured. Everyone you call, I can call, you can rest assured. I can get to sales and everyone. I'm asking you each one of them at a time because this is the evidence. Is it that it was guided, part of that decision of not ordering the steam plant was guided by the recession that began in 2009?
I don't believe we have provided that as a reason in any of our
Well, I am going to, I really should have brought them, because everything you see here is going to be from your testimony. You must have,
What I was going to say is that the impact of the recession would have been decline in partially responsible for decline in sales.
Right. So I am going through every reason that you give me, Mr. Blackman, one by one. So are you saying that part of the reason for not ordering that equipment back then was the recession which began in 2009?
I would say part of the reason would have been decline in sales.
Right. Now, I'm not getting to sales. I told you I'm going to
Mr.
get to
But I
sales.
haven't-
Mr. Vent, the witness have answered
Oh, my God,
your
that is not the
question.
case. We don't give evidence
but-
like that,
No,
Mr.
but
Chairman.
you asked the question, and the witness have answered, and what evidence are you relying on that the rest, that we could consider?
Mr. Chairman. Hold on. We're going to come back at this. Mr. Chairman, I don't have the transcripts here. But, Mr. Chairman,
Which transcripts?
this
Which
is
transcript?
the transcripts of Mr. Blackman, who in his first testimony, they might be available. I told you, I told you I had the office last night because when I leave here, I can't just do lightning power. So I went to sleep 1 o'clock this morning, deal with matters that relating to the office. But I'm telling you, in relation there, one of the arguments that Mr. Blackman stated was in part related to the recession which began in 2009. And I'm going to address every single one. If that is not one, let's proceed.
Mr. Wang, if you are relying on any document in any of your cross-examinations, the document needs to be before the commission and should have been served on all parties so that we will know exactly what you are referring to.
But
So unless you can point us to the document upon which you are relying and quoting from, you may need to change your tact when it comes to your questioning.
I appreciate that. I really appreciate that. This could be a little bit more difficult than it need be, but you don't worry. Mr. Blackman?
Mr. Vane, would you like some time to prepare your questions and we could move on to the...
That would be helpful because
Yes.
rest assured I'm not going anywhere.
Okay.
You rest assured.
Right, so we will give you some time to prepare your questions and
And they all
we will revert to you.
I appreciate that, but you can bet they're all fully prepared here. But what has happened is that I see the tactics, but thanks for the additional time.
Okay, what tactic though, but anyway, let's move on to... Oh, okay, okay.
No.
Okay, so Lieutenant Colonel Brown, would you be able to cross-examine the witness at this time?
Good morning, Mr. Chairman and members of the panel, and especially good morning to Mr. Blackman. So, in answer to your questions, I'm happy to give it a try. So, if we can proceed. In the interest of full disclosure, so could I just take a minute for the records to clarify a few points about the coalition's interest in this process, about myself and the line of questioning that I intend to follow. I had previously explained that the cooperative coalition represents the collective
But
cooperative...
Mr. Brown, I think you would have given some of that information in your opening statements.
I did.
So just go on to the question. So in your opening statement, you provided a lot of that information. So if you could move to cross-examining the witness.
Thank you, sir, for your guidance. Good morning, Mr. Blackman, again.
Good morning.
We've had the opportunity to read your affidavit and go through your written evidence where you make your case for an increase in rates. I want to thank you for the candid responses that you've actually provided so far. However, I have a couple of questions, but before I start, there are a couple simple questions that I think just listening to your responses we can agree on quite quickly, and that will save me and you quite a lot of time. And I just put them to you just to ensure that we are on the same playing field. Can we agree, sir, that the Barbados Light and Power Company is a regulated public utility that was created specifically to facilitate the availability of electricity services to all Barbadians, and that the key stakeholders of the Barbados Light and Power Company are the customers and the general public for whom it was created, the franchise regulators, namely the Ministry who regulate the licensing and all that, the Fair Trading Commission, responsible for the operational regulators, the investors of capital, and to a large extent, the employees of the company. Are we generally agreed on that, or do we need to argue a little bit about that?
You know, it sounds like you have described most of our key stakeholders in that list, so.
Perfect.
I've
known you, let me just for the record say I've known Mr. Blackman for many years, and we've spent many hours arguing, and I tend to know where he will agree with me, sir. Can we agree, Mr. Blackman, that Barbados Light and Power Company is 100% funded by the rates that are paid by its customers, the people for whom it was created, the people who pay their contributions through the rates that are set by the FTC? Yeah, have any differences?
No, I wouldn't put it that way. So in our submission, we would have given the source of funds for the business. The source of funds, which is in the capital memo, would be equity, debt, and customer deposits.
Okay, thank you. So we have a little bit of disagreement. We can talk about that. Can we agree that the holder of the franchise to operate the Barbados Light and Power Company comes with a number of responsibilities? I will list three that I want to be for the record because it is going to be important to some of the questions I want to ask. First of all, that franchise holder is required to uphold in good condition the infrastructure that is needed to provide electricity in Barbados, and also to improve that infrastructure for the reasonably anticipated future needs of customers. So not only to maintain the standard of the infrastructure, but also to prepare the infrastructure for reasonably projected improvements that you can anticipate for the future. Is that a reasonable?
Yes, that is reasonable.
That is the responsibility of the company. And this is the responsibility to operate the business safely and on a continuous basis to provide service to customers as specified in the standards of service set by the FTC.
I would agree with you.
So I tell you, I know you very well, Mr. Blackman. It is the responsibility of the company to operate with prudence to minimize costs in all areas of operation because these costs eventually get passed on to customers. So prudence is a key word in the electric utility.
I agree. Yeah.
And in return, I'm suggesting to you, finally, that the franchise guarantees to the franchise holder exclusive rights to sales of electricity in Barbados without any competition.
That is incorrect.
You can argue about that.
Well, we should
And that it is guaranteed a prescribed rate of return on invested assets as determined by the Fair Trading Commission.
That is also incorrect.
Okay. We can. Would you like to tell us then how the franchise is rewarded for holding?
Certainly, the franchise, so the first question was whether it was exclusive, and it isn't. It's non-exclusive. As far as I know, always has been non-exclusive, meaning that multiple persons can be issued a franchise. We've never enjoyed exclusivity in that regard.
Thank you. Could you tell us who another person that has held the franchise?
That holds a franchise at this point in time?
At any point in time so far?
At any point in time, I'm not aware of any. There
So
are several
Light and Power has been
persons.
the only person to hold a franchise so far?
For generation, there are multiple persons that hold licenses for generation, as you know.
I was talking about
So-
the sale of electricity to customers.
The sale of electricity at this present time, Light and Power holds a non-exclusive franchise for the sale of electricity.
And is the only person to hold that franchise.
It's the only one I'm aware of.
Thank you very much. That clarifies that. So I think we are on the same track. I apologize for having put it badly to start. So can we then agree that we have just defined an entity, namely the Barbados Light and Power Company, that has been conceived and established through a number of laws of Barbados to provide an essential service to Barbados, and that the current holder of this franchise holds the license that expires in 2028. So that we know what we're talking about when we talk about the Barbados Light and Power Company.
But I didn't get past the question before, which I didn't agree with. So the one about guaranteed returns. But nonetheless, if you could repeat that question.
Okay, no, sorry, I apologize for that. I'm very interested in your response to the guaranteed returns of
Yeah, returns aren't guaranteed.
Okay.
The FTC approves what they consider reasonable
Approved
returns.
approved returns.
Approved
not-
returns, that's
Okay,
right.
I stand corrected.
If you
Thank
could
you.
restate the last question.
I appreciate that correction. And then I was saying that based on what we've quickly agreed between the two of us, we seem to have defined an entity, namely the Barbados Light and Power Company, that has been conceived and established through a number of laws of Barbados to provide an essential service to Barbados, and that the current holder of that franchise holds a license to do it until 2028.
That is correct.
Good. This was so easy, I can't believe it. So we have a clear picture of what we're talking about. Now, given the above, Mr. Blackman, here's my first significant question to you. Who would you say holds the formal legal responsibility for planning and executing the energy future of Barbados? So you have a situation where this company, this public utility was created by the laws to look after the electricity needs of Barbadians. The laws specify how it is supposed to work, how it is supposed to be rewarded. Who would you say holds the ultimate responsibility for defining the electrical future of Barbados.
So Barbados Light and Power, we are responsible for executing policy that is established by policymakers. And to the extent that policymakers have identified what the energy mix needs to look like, or set specific objectives and goals for the energy and by extension the electricity sector, I would have to say that those policymakers set at a very high visionary level those objectives, and the company, as a key stakeholder, as we discussed before, executes on those policy directions and directives that are given.
Absolutely perfect. I would have to give you 100% for that. I agree 100% with your response to that. So national policy is set at a high level, and the responsibility of the franchise holder is to execute the electrical energy part of that for Barbados.
Yes.
Thank you very much. So here's my second question. What are the principles underlying your application for an increase in rate? In other words, on what basis has the management of Light and Power determined that it is prudent to approach the Fair Trading Commission to have a review of the rates with the intent of increasing those rates?
So I believe I provided that in earlier testimony yesterday, and is included in our general memorandum as the basis for the application or outlined therein. Just give me a second. I believe it was paragraph 10 that gave a summary. Of course, the full memo sets the context, but the primary factors would have been the increased cost of operation, including depreciation, lower sales in the business, clean energy transition investments that we have made and continue to make, and meeting the policymakers' mandates for restructuring of the sector.
Okay, I actually did get the chance to read that, and I actually have noted those. From my perspective, sir, those represent fairly subjective. When I talk about principles, remember I said we agreed that Barbados Light and Power is established by law. One of the things I've found since I've been exposed to this whole thing, this is about a year now, is I'm extremely impressed with the quality of the law that regulates Light and Power. When I therefore read that law, I'm going to read the section for you, and I'll tell you why I use the word principles and what I mean by principles. In the Utilities Regulations Act, Chapter 3A, it says the functions of the Commission under this Act are, in relation to service providers, to establish principles for arriving at the rates to be charged, to set the maximum rate to be charged, to monitor the rates charged to ensure compliance, to determine the standards of service applicable, to monitor those standards of service, and to carry out periodic reviews of rates, principles, and standards. Now, I'm extremely impressed. As you know, I'm an engineer, and we engineers operate by rules. And when we make decisions, the decisions are premised on those rules. So the question I was asking are, somewhere there must be a set of established principles that would have been established by the Fair Trading Commission, which you would be referring to when you to guide your decision that there's a, for example, what you, in your section 10, you refer to a 38% increase in cost of living over the period, or something to that. Something, you know, I just pulled that out of the air. No, sir, that's very, very subjective. And certainly I didn't see any regulations in the act that says if it passed 30%, you can get a rate increase. If it's less than 1%, you can't. So from the coalition's perspective.
Chair, if I may help intervener, Lieutenant Colonel Brown. He's asking about the principles, and he said he wasn't aware of anywhere The same legislation he is referencing at section 10B4 says inflation is a factor, and at section 10 he will find all the principles that inform the rate making process.
Well, I thank the council for that guidance, sir. But when I read the act, it says that these principles were to be established. That is the first function of the Fair Trading Commission. It didn't say that I will find them in the act. It also says that these principles are due for regular review. So I didn't expect I will find them in the act. I expect this to be something that will be issued and reviewed on a regular basis by the Fair Trading Commission, because that's what this section here says to me. If council is saying that this is not right, I'd be very interested in that guidance.
Lieutenant Colonel Brown, you should ask the witness questions relating to the Barbados Light and Power Company and not questions relating to the interpretation of the Fair Trading Commission's Act. So,
I appreciate all the guidance, but sir,
but the principles
the Barbados Light and Power Company is making an application for an increase in rates to Barbadians, to my members, sir. I see in the act it says that the whole question of rates are predicated on a set of principles. I need to understand those principles, because the truth is, sir, if the principles are indeed there, and I have known Mr. Blackman for many, many years, if they are there and he looked at those principles and based on his calculations determined that a rate increase is indeed due, we will have lots of respect for that. But we need to see the principles. Where did the FTC establish? And we asked those questions and we didn't get a response. We assume that Mr. Blackman, since he made the application, since he must be aware of this act, he must have access to these principles so that he could have decided to approach the FTC for a rate increase. And we were just asking for guidance. I have known Mr. Blackman for years, and I know that he tends to be very candid, that he answers questions. So that's the reason I asked him, sir.
And we've just directed your attention to section 10 of the utility regulations. Yeah, 282. So the principles for rate making and principles are found in that section. So we direct your attention there.
So I'm not going to repeat my answer that I gave to council.
So I would just like you to ask the witness a question relating to the application.
So, Mr. Blackman, on Friday, your council suggested to us, and you seem to have agreed, that some initial funding for the self-insurance fund was provided by shareholders back in between 1993 to 1998. What we understood you to be saying, I'm sorry to go back to this, but there are a number of things that are not clear, and it's not complicated, so I'm pretty sure we can arrange it up fairly quickly. You suggested to us, our understanding of what you were saying is that shareholders injected funds into the Light and Power to offset the difference between the actual insurance costs paid in that period. Because I do recall, sir, and we do concur with your conclusion that there were astronomical increases in rates in that period. We recall this was after Hurricane Andrew or something like that, and that there's a period of intense hurricane. And what was difficult to get was reinsurance. So therefore, reinsurance itself became a problem. So we agree with that. Okay. So our understanding is that you're saying that during the rate case, there were initial projections in the region of $780,000 for insurance costs, self-insurance costs.
739, I think, was the figure.
Exactly.
1983 was the actual cost, 739.
Perfect. But the reality was more like just over $4 million.
No.
The actual cost.
I believe I clarified it in a way yesterday that may have made it a little clearer. I could.
Yeah, you did give more details, but I didn't write that down. So essentially, the costs at that time, I think you were alluding to, would have been the costs of around 739,000 would have been what the cost of insurance was at the time of the last rate decision. Right.
And that would have increased over time, such that over the period 1983 and 2010, between that period of the two rate cases, what would have been included in rates essentially would have been that number multiplied by the number of years there, which is around $20 million. Over that same period, or third-party insurance costs was in the order of 71 million. So that's 71 in comparison with 20 million that would have been in rates.
Right, quite
just to
significant.
complete the story there, on top of that 71 million would have been a further, I think it's 99 million, I've said 98 yesterday, and that somewhere in the order of 99 million would have been contributed by the shareholder for the purpose of self-insurance.
Perfect. That's even more detailed than I actually expected for this in response to my question. Now, what we want to clarify, are you not actually saying, and I'm just trying to make sure we understand what you're saying, are you not actually saying that funds that were paid into Light and Power by customers that would otherwise have been declared as dividends, had it not been for this discrepancy in the cost of insurance, were directed to pay these insurance costs instead of being diverted as dividends for shareholders? As opposed to a situation where the shareholders actually injected funds into Light and Power to cover the difference between the actual cost and the anticipated cost. So you see the two differences?
Those are two different
Right. So
premises.
just for our records and
The
for our
former,
clarity,
it
which
would
is
be-
the,
It's the former, which would be that funds that would otherwise have been paid as a return
Okay.
to shareholders.
thank you very much. But sir,
in the establishment.
am I unreasonable to suggest to you, sir, that these are not shareholders' funds? These are funds, these are Light and Power, the company's funds. That would, in other words, from our understanding, and please understand that what I bring is a layman's view to this thing. My members need to understand, if you're going to invest in energy, what we're getting involved in and how it works. So our understanding is that funds come into Light and Power from customers. And just to give an idea of what we're talking about, since the last rate case up to the end of 2021, we're talking about something like $6.3 billion coming into the company from customers. These funds are used to cover the expenses and liabilities, and the difference between those expenses and liabilities and the revenue is called income, net income. That net income belongs to the company, Barbados Light and Power Company, doesn't it?
That's right.
Okay, good. It is out of this net income that this excess funds for insurance would have been paid. So Light and Power itself paid the cost of insurance, whether it was what was budgeted in the rate review or what was actual because of the chaos that ensued in the reinsurance market at that time. I am fully aware of that. I happen to have been the chairman of an insurance company in that period, and I was fully aware of what happened in that, so that we understand that. But those funds came from Light and Power's net income.
Where in Light and Power would it have come from?
From the net income.
No, so it seems to be maybe a misunderstanding with source of funds
It is,
for
and it
the
is,
business.
that's what we're trying to clarify, so.
Yeah, the source of funds for the business would be equity, debt, and customer deposits, as we've laid out.
The source of capital?
Source
is
of
that.
capital for the business.
Okay, right.
Right. But retained earnings from that income go into, make up the equity of the business. The equity of the business is the sum of our share capital and retained earnings. That's the link.
And other deposits, right, I agree.
And that's, well, customer deposits would be
That's right,
another
right.
source. But that's the link between, so essentially retained earnings go into the equity component of the business.
It's part of the equity.
And that's the
No-
shareholders' ownership portion of the business. That's what equity, that's what equity is.
No, that's the company's asset. That's the company's equity. The shareholders, the shareholding is the shareholders' equity.
I think you're wrong there.
Okay, well, but when the financial experts come in, we can clarify
Yeah,
that.
they will deal with
Yeah,
that.
thank you very
The equity in the business is the sum of the share capital and the retained earnings.
Okay, just to close this, because I think I understand what you're saying now, and although we disagree, we'll clarify that. But just to summarize, the way we saw this was that this insurance was paid for by the Barbados Light and Power Company Limited. the fact that it had to be paid for did have implications for the dividends to be paid to shareholders. We understand that. Therefore, when the fund was liquidated in 2016, as far as we are concerned, those assets belong to the Barbados Light and Power Company, and if this, and ultimately to the customers who would have paid as part of their rates to contribute to this self-insurance fund. To the extent that it was determined that this fund was overcapitalized, is an admission that these customers were paying from 1993 to 2016 some proportion of rates
But
above what they should have been paying if it had been correctly calculated, projected. And therefore, it is beyond our comprehension that it could be expected that having decapitalized the fund, the cash generated from that could end up in the hands of the shareholders.
It's a wrong premise there.
Okay, no, the reason I ask you this, Mr. Blackman, is to give your financial experts a chance to actually research it so that when they ask them.
Before it goes to them, just to correct a misstatement that you made about customers overpaying for insurance. It's exact opposite that I described. Customers, we know what customers paid during that period, or what would have been built into rates, because I shared that.
Right.
Over that period, what would have been included in rates was in the order of 20 million if you added up all between 1983 and 2009. What was actually paid, and I know I'm repeating myself, but I think it is worth repeating, would have been 71 million, on top of which another 98 million was required and set aside for self-insurance purposes.
Mr. Blackman, last thing on this. Just answer these questions directly. In the period from, tell me if I'm wrong. I will ask you to confirm if I'm really talking foolishness or if I am on tap. Extracted from your annual audited financial statements, the total revenue paid into Light and Power since the last rate case to the end of 2021, when we added it, we got $6.3 billion. Something like 2.55 were not fuel. So that is the rest went through, 3 point something went through as fuel costs. That just flowed through. 2.55 was billion net income to Light and Power. That's what customers paid into the entity called Barbados Light and Power. Would you like to tell me how much money came into Light and Power from shareholders during that 13-year period? How much money did shareholders actually put into Light and Power, invest in Light and Power in any form during that 13-year period?
I mean, as retained earnings?
Yeah, as anything.
That balance.
Even if as anything, as a gift.
On the share, it would be in our statements. In terms of adding it all up, I couldn't give you that right now, but it would be reflected, I'm sure, in our, as retained earnings in our.
No, I don't think you understand my question, Ms. Blackman.
Maybe I don't. Yeah.
Right, so between 2009 and 2021, I'm telling you, based on your financial statements, that your customers contributed $6.3 billion to Light and Power. 2.55 billion did not flow through as fuel. The remainder was fuel. 2.55 billion stayed in Light and Power as rates. I'm asking you, in that same period, how many dollars came into Light and Power from shareholders?
And I'm saying that would be reflected in the retained earnings on the balance sheet.
Well, no. I'll answer the question for you. You tell me if I'm wrong. $0, not a single cent, Mr. Blackman.
So you're ignoring the equity
No.
of the business? Isn't that money injected into the business?
That money was in the business from the very beginning.
No, it was not.
Okay.
It has grown over time.
Mr. Blackman, when Emiro bought the shares in Light and Power, they bought the shares from the existing shareholders who were located in the U.S., the NIS in Barbados, and various shareholders, well, including some people in this room. Not a single cent did they pay to Barbados Light and Power Company Limited. The money was paid to the existing shareholders so that they then assume ownership of the shares. But the $200 million in shares were there before they bought it. It will be there after they did, and it will be there after 2028, even if they didn't get the license. That is the reality of a regulated public utility. So what happened in 2021 is that the ownership of those shares transferred from Leucadia largely to Emira, but no money actually came into the Barbados Light and Power Company Limited. I'm telling you, sir, that in the period between 2009 and 2021, the $6.3 billion that passed through Light and Power came from the customers of Barbados. Full stop.
Mr. Chair, in terms of the evidence that's being stated, we would again request that it be put in the form of a question. I believe the last quote was Lieutenant Colonel Brown saying, "I am telling you that XYZ." It would aid the witness if he's actually asked a question so he can respond to it, sir.
Yes, Mr. Brown asked the question, the amount of money that was invested by the shareholders directly into Barbados Light and Power Company. I think the challenge came in terms of how the witness understood the whole question of equity. Because Mr. Brown, I believe, is asking a question related to the stated capital, while the witness was answering in terms of retained earnings. And therefore, I think Mr. Brown was trying to get an understanding from the witness as to his understanding of stated capital versus retained earnings. So I guess that the answer provided by the witness did not make that distinction between retained earnings and stated capital. The witness provided an answer for the overall equity of the company, which is made up of both stated capital and retained earnings. So the witness, Mr. Brown, is seeking to find out if during that period, if your stated capital would have increased.
No, I don't believe it would have increased during that.
Right, so that is the question
Okay,
that
thank you, Chair.
Mr. Brown was seeking to address. Because the growth in retained earnings, which would result in a growth in equity, would not necessarily be derived from the shareholders.
Right, yeah.
But the retained earnings would have come as a result of undistributed profits.
That's right. Thank you, Chair.
Thank you very much, Chair.
Well, Mr. Chairman, sir, tell you the truth, if I was a little younger, I would have adopted you as my parents, sir. I really appreciate the guidance and the clarification, sir. You said it much better than I could ever have said it. So, Mr. Blackman, thanks for that clarification, and we actually genuinely understand better now, having discussed that. Now, can I go to your affidavit? As I said, we went through the audit, your evidence, and there are some things that we really don't understand, and I know you long enough that I know that if we talk to you for a short time, we will have a very, very clear understanding of what is actually going on. Now, in your affidavit in item 10, you refer to this situation where 35% of the residential customers use less than 150 kilowatt hours per month and benefit from the lowest rate. And then you went on to say that in the proposed rate increases, these rates were so low that they'll be something like $6 or $8 per month more, something really impressive. That, I mean, from a PR point of view, sir, I must tell you, I congratulate the company on doing that. And if it was there, we'd probably do similar things.
Sorry,
But-
where are you reading? Paragraph 10 of the...
Your affidavit, not the general.
Oh, okay.
So you recall that thing about 35% of the residential customers less than 150 kilowatt hours. No, but that's just the point that you were making. The question I want to ask for clarification, because this is concerns that we've had from our membership. Are you aware, sir, that even if you give that 150 kilowatts free to that segment of your customers, when the rates are applied to businesses, supermarkets, hair salons, stores, those business people simply pass the higher rate on in markups on their products. Now, the unfortunate thing with these 35% of customers that your PR is targeting is that they cannot pass to anybody. So ultimately, electricity is such a fundamental pillar of society that once there's an increase in rates, this increase is going to be felt by the people at the bottom who cannot pass on to markups. Would you agree with that, sir? That summary?
Not entirely, no, because as a business ourselves, we have a responsibility to manage our expenses. And yes, you mentioned a 38% increase in inflationary pressure. as a business over the 10 years, yet internally, we have taken measures to manage our expenses in a way that allowed us to defer the ask and request for an increase in rates. That is something that businesses do. And so I wouldn't agree that it's necessarily a direct pass-through, because businesses would seek to manage their expenses in a way to minimize the pass-through to the customer and remain competitive.
Very impressive answer, Mr. Blackman. Again, well, I mean, as I said, I've known you for years. But does that mean then that Lightning Power is going to withdraw your application for a rate increase in light of, based on the sentiment you just expressed, that you are responsible and you're therefore not going to pass this strain? Because I'm sure you are aware of the strain that this actually placed on many of my members, on many ordinary Barbadians. And given the conscience that you expressed just now, does that mean that Lightning Power is contemplating withdrawing the application for an increase?
No, it doesn't.
Well, that's the same thing that the supermarkets will say, sir. So despite the conscience that they have, they will actually and say they can't do anything about it because they have to continue operation. And the reality is, it goes. So the question I really want to ask, because I know the chairman is going to ask me to ask the question. Are you aware that ultimately these increases will go on to the very 35% of customers that you addressed, to try to say that you're moderating the impact of the increase? Do you admit and agree that ultimately, despite the good conscience of most business people in Barbados, they will have no choice but to pass it on, just like Lightning Power has no choice but to go ahead with these rate cases because you want to remain viable?
So we have lots of testimony and evidence in relation to the rates, the design of rates, and the impact that will have on various customer groups. One of the witnesses coming up later, Dr. Adrian Carter, will be able to expound on that and explain the specific impacts. So without going into the specific details in relation to impact on individual customers, what I would say at a broad and high level is that we have identified in our application the impact on that group of customers. We have identified the impact across the board. And we've also identified some of the benefits that are coming with that are coming along with the application in terms of the plant, the clean energy bridge that we put in, and the mitigation that has against the rate increase that we're seeking. In fact, we have already seen, for example, in August, the impact that the fuel price and fuel savings have had from that plant going into service, and that in effect mitigates against the request that we're making, so that the net effect and overall what you're seeing here coming out of this application is not as significant even as the $6. That's before the clean energy savings. The impact is actually lower than that when you factor in the results that we're getting from the most recent investment. So the specific details on impacts, I will defer to a later witness who will be able to expound on that and give exact details. Some of it is in the evidence already, but just on generally, the ask is very reasonable in the context of the investments we've made and the fuel savings that we've derived from that.
Okay, thank you. I'll be guided by that, and I look forward to the opportunity to talk to Dr. Carter. So can we move on then to the next, item 12, then, where you refer to the test year, the selection of the year 2020 as the test year. Can I just ask, generally, this is very general, what is the point of selecting a test year? Could you tell us why that is important?
Yeah, the test year is important. It's meant to represent a year that you can use to establish the revenue of the business, the expenses of the business, and a basis on which to identify revenue requirements and ultimately rates. So in going through the process, you need to start with a year of information and apply then the tests in relation to revenue requirement and so on to that test year that has been selected.
Right, that makes a lot of sense, and then what it allows you to do is to actually come up with information that is actually representative of the kind of period you're talking about so that you can make sensible projections going forward.
Yeah, because you would make
Okay.
adjustments for known and measurable.
Can I draw your attention to your case presentation on page 761? I don't know how difficult you can, if you can find that, 761?
One sec. This is the sales projection memo.
That's right. And there's you actually have a graph represented there from the Barbados Statistical Service and the Central Bank.
761.
Yeah,
Yeah, this is the central bank report.
There's a graph that you have represented
Yep, it's up on my screen if the IT guy wanted to pull it up.
Perfect. Could you, I just wanted to, well, it's difficult to say from there, but just if you can talk it through it. Which part of that graph represents 2021? I mean, year 2020?
I don't know if you can see the icon on the screen. This
Perfect.
part here.
Exactly. Do I even need to say anymore?
Absolutely.
No, because, well, I think you need to say something, because my expectation is that if we're looking at a period, and you want to select a year that is representative of that period and of the period expected to come, the bottom of that graph clearly cannot be. I mean, I don't want to go into any of the statistical information. We've argued engineering things for I remember we argued a whole day about probably the color of the sky or something like that. So we can actually argue a lot. So we don't need to do that. Just a look at that graph, Mr. Blackman, should tell you that that period cannot be representative of any period near to that. That's the most abnormal, atypical period in the last 20 years, or even maybe any reasonable projection of the next 20. Would you agree with that?
Colonel, I was just going to ask.
I know. I expected. I saw you looking into it, Mr. Chairman.
Instead of offering testimony.
For the purpose of setting, so generally, as a citizen of the island, or absolutely that year was unusual in the scheme of things. For the purpose, though, of setting rates, as I would have indicated before, you, in the test year, make adjustments for certain adjustments to the test year in question, which was done, for known and measurable changes. And sales is just one element of the assessment and analysis that is done. Expenses and costs also are critical. And recall that, as I had indicated at the start, we would have had to, we had started planning from as far back as 2019 because of the challenges and what was happening both then and what we were expecting to happen in the business in relation to performance. Even with the sales fall off, we see the impact that it's had on financials. And then 2021 has continued to slide in the face of sales actually improving slightly over 2020. 2021 is still continued to slide. And this year, potentially without relief, we would have had a continuation of that trend as well. And all of that is to say that sales is not the only factor. It is an important one, and it is there, and yes, it plays a part. But that in itself is not a reason to eliminate a test year.
Okay, point taken, and no argument from me. I actually agree with you that obviously there's more to it than sales. So let's look at something else then. I have a graph, but I don't think that I'm going to be able to get a chance to put it on the screen. But it is a graph of dividends paid by the company over the period since the last rate case. What was the dividends paid in 2020?
No dividends were paid.
Zero.
2020. Yeah.
In which other year was there a dividend of zero paid?
Since the last rate case?
Since the last rate case.
No other year as far as
No
I'm
other
aware.
year. Could you say what the average per year of dividends was over the period, including the year when it was zero?
I would have to calculate it.
But I could tell you, you could tell me if it's all right.
You tell me. And let me bring up my calculator.
538 divided by 13. Sir.
538 is...
Divided by 13.
Yeah, no,
Right,
538.
right. So we
Over that period.
Would you say that 2020 is an unusual year in terms of dividend payments?
It was in terms of dividend payment.
So it's unusual in terms of sales, unusual in terms of dividend payments, unusual in terms of net revenue, unusual in terms even of employee attendance at work, because we had people who were home, shut out, working in completely different circumstances. Is that not true?
The working circumstances were different, yeah, yes,
Okay, but let me put the question another way before the chairman get hold of me.
right.
What was, tell me something that was normal about 2020 that would suggest that it should be selected as a test year. And just something that is actually normal about the rest of the 13-year period we're looking at.
Normal in the context of selecting a test year would be closest proximity to the date of filing.
And you
Historical
actually
test year
said,
in which you have a full set of financial data. And then in the context of the forecast, 1 year of which has been actualized, shows that on the basis of setting rates on the 2020 test year, the company would not over-earn even if it had been applied to 2021 and the forecast that we have there. And that evidence is shown throughout the 5-year forecast. So the reasonableness is on that basis.
okay, and I'm sure the chairman is not going to let me cast any aspersions, but let me see if I can put it nicely so that neither him nor Mr. Allen would actually get offended. How would I be able to convince my members that 2020, that the applicant would not have deliberately configured 2020 to suit their purpose? In other words, the applicant decides when they will come for a rate case. It isn't that that there's a set date and you have to come that day. So you decide when you apply for a case. The guidelines seem to be the last year when you have complete information. Are you not concerned that that provides the applicant with the opportunity to configure a suitable year that allows the figures to prove their case? How would I convince my members that that is not a problem?
I thought for a second you were blaming us for releasing COVID, the way the question was phrased, but
Well, actually, you know, that has not been concluded as yet.
fair enough. The explanation is, as I would have indicated before in an earlier testimony in relation to the selection of the test year, simply because it is the year closest proximity with full financial data. And when we do the assessment on that year and determine rates on that basis and forecast based on those rates on our forecast and test it with a full year that we can test, we determine that those rates, even with that test year and the sales as they were, would not result in an over-earning position. And at the same time, it would have been irresponsible, we believe, to further delay the request for rates beyond what we had already delayed, as I indicated earlier, because we had started the process in 2019. We had delayed at the request of officials who we were working with on the issue in relation to our franchise expiring, and then subsequently events like COVID and ashfall and so on. So all those factors considered and the need for urgent relief meant that we needed to move forward with what we had in front of us. And some comfort can be brought from the fact that we've made a forecast 1 year of which you can see what the actual results, or you can compare the actuals with.
Actually, the truth is, Ms. Blackman, because I actually understand your position, sympathize with it and all that. But I think you also understand mine from the perspective of transparency. All my constituents don't know you like I do. They don't know Lighting Power like I do. So to the extent that there could be suspicions, I think it's important that, this is why I actually am very concerned about this thing about principles. There need to be guidelines laid down that determine important criteria, like this business about which is a test year. If you're going to have a last rate case started in 2009, this is 2022. I mean, a world of things happened in that period. We just discussed around 2020 and we spoke about in fact, the only thing about that is how chaotic it has been and continues to be. To the extent that somebody is going to just pull a year out from any part of that period and try to use it as a test year is actually a problem for us. And basically what it calls the question is this business about the principle that is going to be applied in deciding a test year. And I just want to ask, are you comfortable with the lack of transparency that seems to be involved in some of these key decisions? And the similar questions will come when we talk about some other aspects of the rate case.
I would disagree with the premise in the question that there's a lack of transparency. I mean, there aren't many businesses that are doing what we are doing here. There's a tremendous amount of transparency being a public utility that's regulated in the way we are. Not many businesses will be here, going through a process like this. So there is transparency. The fact you're asking the question and are reviewing the information and the material that we submitted, and we're having this discussion is evidence of that. So I disagree with the premise of the question.
Okay, I appreciate your answers.
Mr. Brown?
Yes, sir.
I would just want to state that when you speak to the whole question of principles, the Commission does allow in any rate hearing that the rate applicant use the year closest for the purpose of filing. It's for the purpose of filing the application. It has not necessarily been approved. And part of this process here is for us to interrogate the data that have been supplied in that particular test year to see whether or not it is appropriate. We may ask the applicant to recalculate based on another year. So the purpose of using that particular year is for the purpose of filing the application. So that is the principle that is used. So you could ask your question in relation to any data that has been supplied in relation to that particular, but that is the normal principle, that they just submit the application using the most recent year prior to the application as their test data.
Thank you for that guidance, Mr. Chairman. But as you will see when I come to another item just a little bit on, one of the problems in dealing with MISR is that I tend to get involved in very fundamental issues because as an engineer, sir, to me, if you don't have a good foundation, you have serious problems. So I'm one of those engineers who's foundation focused. And the actual principles and the existence of them, the foundation on which you're going to build the whole case, sir, tends to be the area that concerns me most. And I think if you have a good foundation, the building tends to go up very, very easily. But not to be distracted from your guidance, I appreciate that. Mr. Blackman, can we move on then to the whole question of standards of service, which you touched on in 14 of your affidavit?
14? Sure, yeah.
You spoke about the standards of service. And the question I have really, you said that, for example, the applicant conducts regular surveys, and this is how you know. Here's the question I have. Who measures the standards of service? Who actually do the measures? What transparency is there when you say that how impressive your performance is, for example? One of the concerns that we have from our customers, let me give you a couple of the concerns and then I'll ask you to respond and tell me where we are wrong. The impression that my members get is that over the last number of years, more than 5, there have been a visible reduction in the level of maintenance made done on the overhead system, for example. And a resultant degrading of the overhead infrastructure. We get the impression, and certainly in the coalition and the co-op, because of our interest in energy, that there has been a clear lack of leadership in the Barbados national energy policy. Now, when we started, we agreed that there's a situation where there's national policy set in Barbados, and we know that the Barbados government has actually set an innovative, we're leading national policy for energy. It's called the Barbados National Energy Policy 2019 to 2030. What is missing in that is the kind of leadership that we would expect from the people in this country who have responsibility for taking energy forward, who have the expertise on board to really understand what the issues are, who understand what the pitfalls are, and who really could speak authoritatively about what needs to be done in Barbados, how it needs to be done, and how it needs to be laid out as consultants for government, as consultants for the potential IPPs, and all those. The question is, okay, I got a little bit lost here just now. So there's a lack of leadership in the national energy policy. We are, well, I don't want to repeat, but the concerns about the generation plan, I mean, I think that has been exhausted, so I'm just going to mention that that has been an area of major concern. And then last of all is the degraded catastrophe insurance fund. Now here it is, we live in a time of climate change where the most ridiculous things are happening. You're aware, of course, that our friends in Nova Scotia recently got struck with a hurricane.
On Saturday.
If I'd asked you last week about bets about between Barbados, Legend Power, and Nova Scotia Power, about the chance of being devastated by a hurricane, what would you have given the odds between Barbados to Nova Scotia being hit with a hurricane?
I would have actually bet on them ahead of us, given the history.
Yeah, but that's because of you fellow do a lot of research, you know things. But what do you think the average fellow would have bet? I know you for lawyers, Mr. Blackman. I know that you would.
So their history has been a little worse. They have hurricanes and what are called nor'easters that can be devastating. So they have those high wind events more frequently than, as you know, we had our first hurricane in what, 60-something years last year.
Okay.
We've had storms and brushes, but nothing compared to what they see up there. So.
But given the reality of climate change and what's been happening with the weather and these ridiculous systems that go from zero to Category 4 overnight, are you not concerned that far from reducing the level of catastrophe insurance, you would think that a place like Barbados will be going in the other direction to look at the eventuality? When we see what happened in Bahamas, for example, Grand Bahama, in Dominica, if that were to happen in Barbados and I were to ask you to give me a projection of the cost of restoration, how on earth, I mean, I must tell you that my members, we are completely lost as to any kind of logic that would suggest that there should be a reduction in cover. And even, so I was saying, even in Nova Scotia. So by the way, what catastrophe insurance does Nova Scotia have?
I am not
Self-insurance?
I am not aware.
I'm willing to bet you they don't have any.
I am not aware of their insurance.
So we had this innovative scheme in Barbados that was a world leader in terms of creativity, effectiveness, profitability, and we allow it to be decapitalized at the time of climate change. The whole point is, sir, when you say about how well you're doing and about the quality of service that is being provided, do you understand the concerns that customers have from their perspective? And I outlined just a couple.
So there were a lot of things packed in the question. I'll deal with the last one.
Because there are a lot of concerns, Mr. Blackman.
Fair enough. But in relation to the capitalization of the self-insurance fund, as mentioned previously, it's assessed on an ongoing basis. And what I would want to say to you and your members are that it is important that we manage that fund in a responsible way. And if it is overcapitalized, and we do, just as you do engineering studies, you do risk assessments with consultants and so on, you don't want to be putting money into something that is already overcapitalized for the risk that is designed to cover. Had we continued to build that beyond what is needed, because we've done the assessments and we have take into consideration climate change and trends historically, we determined through that assessment what the appropriate size would be for the risk in our market. And then we made a decision that is in the interest of all of us and all of our customers and all of your members. Had we continued to put millions of dollars into the fund that's overcapitalized, that would put additional pressure on rates, and it would likely have meant that we might have had to come back or make other adjustments in the business to facilitate. But it wouldn't be prudent to pay more than is needed for insurance when you have already adequate coverage.
Granted, and again, I accept your position that you've taken, but let me put to you that from the perspective of transparency, I would have thought that something that affects this this self-insurance fund does not only protect Light and Power, this protects Barbados, the Barbados government, the individual people in Barbados, because if we were to be struck like Dominica or Grand Bahama, the Barbados government is going to have to fund, if to the extent that their costs over and above, it is, we will all pay the price. So the question would be, even if such a change is going to be made, or had to be made, or is as prudent as you have probably very honestly outlined, we would have thought that this would be a matter in which all stakeholders would have been advised. So in other words, and involved. The fact that this could happen in 2016, surreptitiously, because, I mean, nobody knew about it. You have a board of 3 people, and based on the names that you call, these are all people from Emira, who don't even have a self-insurance fund, from what we know, making decisions about our self-insurance fund in the absence of consultation with the other major stakeholders. For example,
Mr. Brown,
question?
a question and not testimony.
To what extent have the other stakeholders in the BLPC, who we established up front, we established those 5 key stakeholders, to what extent have they been involved in major decisions? And the insurance is a good case in point, but similarly for the lack of generation and all that, what has been the involvement of the other stakeholders?
So every other business, we have certain reporting requirements, and in some cases permissions are required, and in all instances we do the necessary reporting, make the necessary requests, seek the necessary permissions to implement anything that we are doing as a business that requires those things from rules and regulations and laws. And as it relates to the self-insurance fund, we did do all of those things and consulted with those stakeholders that had a role either from just consultation or approvals. Some of those were requested by the intervener team of Watson and Simpson yesterday, and we provide that information as requested.
So, for example, you would confirm that the governor of Barbados and the insurance, the supervisor of insurance or the Financial Services Commission were all properly informed about this transaction beforehand and consulted on the practicability, the reasonableness of the decisions that were intended to be taken.
All of the relevant persons would have been consulted with, approvals sought where necessary, and approvals granted where needed.
I appreciate that assurance from you, sir. Okay. Now, to your general application, and I'll go through in sequence so that we don't waste time and that you can understand, follow what I'm saying. Because the general application, in 2, you said that you started by saying, for example, that there were 2 base rate increases in 38 years, 1983 and 2010. And also, you delayed the application as much as possible because, to quote you, there's no ideal time for a rate review. Does that encapsulate how you felt or what you wrote about the...
Yes.
Right. Can I beg to differ diametrically with your suggestion that there's no ideal time for a rate review?
Yes, you can.
Well, you know what to do it anyway.
I know. Yeah.
But Mr. Dartman, the truth is, right, as I told you, we are guided by the Act. We actually like the Utilities Regulation Act. We think it is well thought out. And let me read for you what it says, and then you tell me if you disagree with my disagreement with you. In section 15, right, it says, the commission may fix a period of time not exceeding 5 years, in respect of which the rates for the supply of a utility service and be the principles for determining the rates for how the service is to be calculated, and see the standards of service will apply. So you have a situation here, from my reading, and you can correct me if I'm wrong or if you say it differently, really the Act that sets this whole thing up says that there is a requirement for regular reviews, and it actually sets a guideline, even if it says may. It sets a clear guideline of what the expected frequency of review should be, and it says no more than 5 years, but it could actually be less than 5 years, and that's up to the judgment of the Fair Trading Commission. In what circumstances then, given this kind of guidance from the Act, can you be comfortable saying that not only were there only 2 applications in 38 years, but that we should be grateful because you didn't hurry and do more? Are these not diametrically opposite philosophical positions?
I don't think so. So in terms of legal interpretation of the act and so on, I'd leave that to the commission and the lawyers in the room. But in terms of just practically and cost-wise, the costs associated with a rate case like this one and the ones before are very high. And the work involved in setting up and having something like this, takes people out of whatever they're doing, like Mr. Wendt indicated, their normal course of duty to be here and testifying and so on. So these are not, simple hearings. They come with
Can I
significant
interrupt you on
costs.
that, Mr.
So
Blackman?
the point I was making is that it's expensive, and you want to find the right balance. I think so that would be my response to that question.
I would like to interrupt you on that because, I don't know, I don't want to assume the chairman's job. Are you aware that Nova Scotia Power has had a rate review every year for the last 10 years?
I wouldn't doubt you. I'm not certain.
Oh, no,
if that's the case.
The information is...
But just so I'm clear, you're proposing that a rate case be held annually.
No, I'm saying that the philosophical position that you've outlined of having only two reviews in 38 years, and that you're doing us a favor by delaying application, is philosophically diametrically opposite to what I see articulated in the act, where that calls for frequent reviews. Now, I agree with you that it is expensive. The fact that we only do it so infrequently, I mean, for example, the first time I'm exposed to this, I'm actually learning. I think most people here probably learning on the job. I did some research in what Nova Scotia Power do, because they're both owned by Emera. And the reality is that it is almost like an equation. You fill in the variables, and it tells you if there needs to be a rate increase or not. And that is my understanding of principles. And to the extent that it is done regularly, what that does, why I think it's philosophically important to discuss it, and you could tell me if you disagree, Mr. Blackman, is that it keeps everybody on track. So that almost from the instant that the company begins to experience hardship, they can recover, because Barbados needs light and power to be successful. Yeah. And to the extent that circumstances change, and the customers can get a reduction in rate. And if you look at the same Nova Scotia Power records over the last 10 years, you will see that for each category of customers, you could actually see like a 1% between 1 year, and then it goes back down 3%.
Sir, if my friend, go, Chair.
Lieutenant Colonel Brown, we would still like the question instead of the testimony. And while you're at it, could you give us an indication of how much longer?
So I can be here for a while, sir. I didn't know there was a time. There's a time limit, sir.
No, not that there's a time limit, but there's also lunchtime.
But sir, I'm not busy after lunch.
Pardon?
I'm not busy after lunch, so I'll be here.
Okay. Could you ask your question and then let us break for lunch? Could you ask your question and then we'll break for lunch?
Okay, sir. I think I've made that point. So if you want to stop at this point, because the next item is probably going to be a little bit longer than that.
I just wanted to clarify my answer to that last question. It depends on the basis on which you are. The basis on which the point was made in relation to the time periods between our rate filings was that as a business, it didn't mean that our costs didn't grow or we weren't exposed to the inflationary pressures that all businesses would have experienced over the period. But as a business, we were able to prudently manage our expenses and our costs to delay for as long as we could coming back for a rate application. And as part of that process and the regulatory process generally, we file our regulatory reports and our financials with the regulator. They're reviewed. And over that period, you can see cumulatively over that period that we haven't over-earned as a business. So those factors are all considered: the level of reporting that is done between rate cases, the evidence that we've put forward that we haven't over-earned cumulatively over that period between rate cases. And indeed, from that evidence that we've been able to manage our expenses, some of our expenses are lower than they were at that particular time, because we made prudent decisions as a business manager on behalf of our customers to hold rates as steady as we could. That's the principle or the basis of making that statement. I'm not taking away from what you are saying, but just clarifying that when we say that, it is testimony in our view of the prudent management of the utility.
Fully appreciated, and I'm not a good person to argue this because I actually see your point. I think I could understand your shoes, but I want you to understand mine. From the point of view of transparency, it is far better on a regular basis for an independent panel like the Fair Trading Commission to actually say that things are on track. It is very difficult, it has been very difficult for me to convince my members, for example, that in the 13 years since there was the last review, what happened was that everything was going perfectly. We were not being robbed and you were doing. The actual inclination of my members is to think that during that period you were making a killing, and now that you're no longer making a killing, you want to get back to the point where you're making a killing. To remove that suspicion, transparency by a system that actually reviews, I am sure you would agree, Mr. Lackman, would actually make life a lot easier for you and actually for me and my members. My problem is that I am put in a position to try to take your position in trying to explain to my members what the situation is, and it's very difficult because you don't really pay me anymore.
Yeah, Mr. Brown, in relation to that particular section of the legislation of which you refer, you should also know that in relation to standard of service, the standard of service is actually only done for 3 years, and there is periodic review of those standards of service. So it's only in relation to the actual rate that we would not have had a review within the last 13 years. But in relation to the standards of service, those are actually reviewed every 3 years. So they're...
Thank you for that, guys, Mr. Chair. But could you then explain what was the difference? I mean, why is the standard of service more important than the rate?
Well, the process is a lot simpler and a lot cheaper.
I asked about importance and not cost.
Okay. And the standards of service that you will see that is normally required to be posted on the applicant's website and things like this, we do look at them having to report on faults and all of these different things. There are different sections, and we would look to see if there are any of those particular standards that need to be adjusted within the 3-year cycle. So that is the process. But in terms of the actual rate that we're requesting of the ratepayers, the applicant would normally make that determination as to when they will come. So I'm just saying in relation to the legislation, and what you're getting into here now is probably rate design, and maybe it is something that we will need to look at, because that is one of the issues that have been set down for discussion for this actual hearing. So that if we look at the whole question of rate design, when we discuss that issue, maybe we may reach a point where we may be able to get to some type of rate design that would enable us to have a more frequent review of rates, as opposed to the current one that we do have.
Highly appreciated. Thank you very much, Chair. And you may recall that this is one of the issues that we have indicated from the very beginning that we concerned us. So thank you very much.
And that is one of the issues that we've set down for discussion at this very rate hearing. But at this point in time, we would recess for lunch, and we would reconvene at 2:15.
Chair, just if I may, just on that matter, not lunch, but the one before, on rate design. I know the way that the hearing goes, we're going to be discussing with particular witnesses, and rate design maybe can look both at the current rate design proposed, but what you're proposing is more like a principle of the way that the commission goes. I was just wondering, which witness are we expecting to deal with that in? Can we identify that? Because I think what you've brought up, as Lieutenant Colonel Brown has brought up, is to me a fundamental thing that has to be dealt with. So if we can, I'm not necessarily to answer no, but if we can determine what is the best time to do that, because I think we need to have a discussion on it, and not necessarily, somebody saying, I can't answer that because of so-and-so. So if we
It's
can
so noted,
look
and
at that.
we will inform you of the appropriate time that we
Yeah.
will be able to
'Cause
have that discussion and the appropriate witness.
Thank you.
Okay. So we now recess for lunch. Okay, we'll now continue with the cross-examination of Mr. Blackman by Lieutenant Colonel Brown. Mr. Brown, I'd just like to remind you that, you know, we have a number of other witnesses to be cross-examined, and if you could be prudent in terms of your question selection to ensure that any question that would have been asked and answered before, that unless you're seeking clarification, that we're asking that you be mindful that there are a number of other witnesses that would be called that may be, in some instances, in a better position or just as good a position to answer the question. So we just want to be fair to all, and we would like you to continue with your cross-examination at this time.
Okay, good afternoon, Mr. Chairman. Thank you. And I will try to be as expedient as possible in getting through the few other questions that I have. Good afternoon to you again, Mr. Blackman. So if you can go to the section, I think it is item 12 in your general application, where you refer to the critical need for the interim rate to be assigned. You probably recall the statement that you made. I am not going to read it because, I mean, I'm sure you're familiar with it. The question is, would you want to review this assessment that you would have made in the application, looking back, to use your counsel's word, in hindsight? Since I would suggest to you that it has proven to be a little bit less than prophetic.
Item 12, paragraph 12.
Starting, it is therefore critical for the viability of the BLPC that interim rate reliefs at the proposed rates be allowed, etc., etc.
I found it in the application. Just one sec.
Specifically, you say that without the interim rate, the company would be unable to fund its planned investments to meet customer requirements, would not have sufficient resources to attract capital, and would be without the financial resources to respond to financial, economic, or environmental shock. I just read that stuff so that you would save you the time having to look for it.
Yeah, no, I have it here.
So the question was, do you wish to review this assertion now in hindsight?
No, I
Okay,
wouldn't
so
have
you-
any reason to.
Thank you for that. A question, what was the current level of retained earnings in the company at this, in the test year?
Retained earnings.
Retained
Let's
earnings.
see if I can find that. Do you
Sorry,
have-
Chair, I just want to make sure I understood the question asked. Is it current or test year? I think
I
you
said
said
in the
both.
test year. In the test year, sorry.
We could help speed it up if you have it there in front of you. No.
354 million.
Okay.
But you know, I don't ask questions that I don't know the answers to.
Correct. Yeah.
See, if you help me to understand, Mr. Blackman, how it is possible to express fears about possible economic and environmental shock when you have $351 million in retained earnings, presumably funds to be invested in plant and equipment and to be used in the ongoing operation of the company, and when you would only recently have seen it prudent to not only decapitalize an insurance fund by $100 million, but then to distribute that $100 million to a shareholder just in 2016. And then just a few years after, you're going to say that you have difficulties and fears about possible economic and environmental shock. It's just difficult, it has been difficult for me to rationalize the two positions.
So I think the whole question around retained earnings, maybe there is some further discussion and dialogue with the Mid-Director of Finance about retained earnings, but that isn't necessarily cash available to meet your day-to-day requirements in the business. And maybe there's assuming from the question, a view that is what that is. But again, I will defer the details around
To the expert
with
witnesses.
the expert accountants,
So good.
economists, and so on.
I appreciate
In
it.
relation, okay.
I appreciate it. Okay, so I can go on then?
Yeah, yeah.
Okay, I appreciate that response, and I will be so guided. The other thing that we would like some explanation, one of the statements you said is that the fear of not having enough resources to attract capital. I'd outlined before our understanding that the way Light and Power operates, over the last 13 years, customers would have paid, not counting the fuel charges, $2.55 billion into the company through rates. The investors would have paid not a single cent over that period. So when you speak about attracting investments, it was difficult to understand exactly what the fear was. Has the company been trying to increase the level of share investment or other liability investment into the company over the period and been unsuccessful in doing that?
Well, we haven't tried to raise additional share capital, if that is your question. I mean, I think in earlier responses indicated that we were managing to a capital structure that's approved since the last rate case, and that we put forward as appropriate even in this one of 65 equity, 35% debt. And we haven't been able to actually achieve that between the rate cases. We've come close. And are somewhere in the order of 70% now, so 5% higher than what is approved as a capital structure. So it is in the context of managing our capital structure that the earlier response was given. Could you repeat the question? I feel like I've missed part of it.
No, we were concerned about, you had expressed in that statement that we read, concerns about the company not having
ability
enough,
to raise capital.
Right, to raise capital.
Right.
And,
So
and we
it's-
couldn't understand because we saw no indication that was an attempt to raise capital. As a matter of fact, what we have noted is that Light and Power shares since during the period are not even on the market. We're interested Barbadians, and if the chairman would allow me to put a little advertisement here now, including the cooperative movement, who are interested in investments in some businesses like the Barbados Light and Power Company, would have the opportunity to actually compete for ownership in some of those shares. We actually would be interested in that. And to the extent that we have seen that door closed, it is surprising to hear you worry about your inability to attract investment, when in fact, we would like the opportunity to invest in Barbados Light and Power, but that is a different matter that I can probably take up with one of the other experts, unless you wanted to say that I'm wrong on that.
And just a brief comment, and again, yeah, the experts can comment on it, but we raised capital to two means, equity and debt. We have borrowed money over the period as well to finance some of our investments. You are right that we haven't raised, we haven't put out an offer to raise more equity in the market, because actually we've been managing to try to bring the equity down to a point that matches the structure that is approved in rates. But I note your interest in terms of interest in investing, and I've noted it.
Oh, that sounds encouraging, Mr. Blackman. On the question of the debt equity and the whole question of capital, I think that I will reserve some, we have some serious concerns about that, but I will reserve that for, because you made a statement just now that it's so diametrically opposite that I know the chairman is not going to let me pursue it. So I will leave that for a little bit later. In terms of the equity ratio. But it seems to us, and you could correct me if I'm wrong, that the company has been largely disinterested in debt and more focused on using equity. Your debt levels, when you look, we actually did a tabulation, and unless I'm absolutely wrong, the average over the last period was 83% equity and only 70% debt. Now, debt is, in the past few years, have been the lowest in generations. Debt now is running in between 2 and 3%. Equity, as you know, in the region of 12% as approved by the FTC in the last rate hearing. So by choosing a large proportion of equity and a lower proportion of debt, the capital expense that eventually it has to be taken up by customers is proportionally higher than it needs to be if, for example, a larger proportion of the capital was funded by debt. So that is a matter of concern, but I suspect that Mr. Hokkaido Jennings may be a better person to talk to about that. So I will not pursue that for your time.
No doubt he is a better person to talk about it, but there's a misconception in your statement in that the rates are determined on the basis of 65% equity. Doesn't matter what the actual equity is, and you are right, it has run much higher than that over the period, and you are correct. We have identified that in interrogatories in our submission as well, that the intent is to bring it in line with what has been approved by the Commission. So fully support and in alignment with that. Just to point out that it is, the rates are on the basis of 65, even if on average it had been running higher.
So just to clarify that I understand what you're saying, and also that Mr. that we try to understand, so that when you're saying that even though the equity ratio is more like 82 to 17, in terms of the charges that are passed on to customers,
on the
it is
basis of
calculated at
65.
65 to 35 as directed by the Fair Trading Commission.
That is exactly how it
So
was
just to
done
make
in
sure we
last
were saying the
review.
same thing.
Yeah.
The other concern we had with this whole question of the attractiveness of resources is a situation where we've outlined this in our opening statement, where what we have found is over the last 13 years, well, not so much 13 years, over the last 11 years since the ownership has changed, that disproportionately high levels of dividends have been paid. I mean, the truth is, the 2 years before ownership change, the average dividend was less than $10 million, it was in the region of $10 million per year. That was the dividend on $200 million in shares. In the subsequent period, the average dividend per year moved from less than $10 million per year to $48 million per year. That was a substantial jump in dividend. Not that we're complaining, because, as I tell you, we're in the investment business. The problem is, how can you say that anybody who have any dollar to invest would jump for the opportunity to get those kind of returns? So you cannot say that you have difficulty in attracting capital when there's no opportunity for capitalists to get on board with this really attractive dividend rate that you have been paying. So we are concerned about that. And the other problem
Mr. Brown,
that's a statement, Mr. Chairman?
No, I'm just want to make a slight explanation. I think the witness would have testified earlier that when they looked at the capital structure of the firm, that they choose dividends as an attempt to reduce the actual capital structure from its current level. So I would recommend that we wait until the expert in that area where we're looking at capital structure, that we can focus a little bit more on that particular approach to capital structure, so that you could raise questions along the line to ensure that we get a full understanding of what is happening here. Because the witness would have indicated that the capital structure in using equity at 12%, that is high, would contribute to a higher weighted average cost of capital. And therefore, that is why they would have chosen to try to reduce that. So that has already been asked, and that has been answered. What we would need to do is to use the questions to ask the experts that have informed them these types of questions, if there were alternative models, etc. So I think that Mr. Blackman would have testified earlier that the approach the company used in their attempt to reduce the equity was through the payment of dividends. So he'd answered that already.
Okay, I'm guided by that, Chair. But just to clarify that, I have a serious difficulty with that explanation, but I will take your guidance that the appropriate place is with the experts. Would you agree with this, if I suggested to you, Mr. Blackman, that the whole question of prudence at the level of an organization like the Barbados Light and Power is best managed proactively in the boardroom, such that when decisions about the fairness and the transparency of the payment of dividends, for example, or the level of investment or the kind of investments that we do are taken, the views of all stakeholders get to contend. Would you agree that that's a far better means of ensuring prudence than waiting 13 years after the fact for the FTC to sit back and review what happened 3, 4, 5 years ago with insurance, or 8 years ago with not investing in generation plant? What would be your response to that suggestion?
That is not what has happened. What has happened over the period is, on an annual basis, we submit our report to the Commission for review, in addition to a host of other reports, some of which you would see, in fact, all of which are either in the application or responses to interrogatories, things like service standards, you know, basically an account of our stewardship of the sector and our operations in the sector. And that's done financially, as well as other performance metrics are shared with the Commission for review. So it would be incorrect to suggest that, you know, decisions are made and between rate cases like the one we're here at today, and there's no accountability or no assessment of the performance of the utility in the intervening period. That simply is not true.
Okay, I appreciate that, but you know, that's not the question I asked. I asked if you would agree that prudence would be better served if such considerations were taken proactively rather than have to be considered post the event. And I'm not bringing into question at all any imprudence on the party. I'm talking about as a general principle, would it be better if when the decisions are taken, there's a level of transparency and inclusion and information exchange among the key stakeholders rather than a situation where all that is being done years afterwards, nothing to do with the actual current situation.
But from my perspective, much of what you've just described does happen. There's if it is in relation, for example, to our expansion plans, you would recall back in the 2012 to 2014 period, the level of consultation that would have taken place when we were discussing issues in relation to plans for expansion, plans for the sector. And so there is a high degree of consultation with our stakeholders on several matters across the board. And we still, at the end of the day, a company with the board of directors, and unless you're suggesting that persons are in the boardroom when certain discussions are taking place, the route to it is consultations, as we've had many examples of over the period. Consultations as well as meetings with the regulator from time to time. Discussions on several matters, that's ongoing between rate cases. It doesn't just happen here.
So can I take that to mean that you're saying that you you agree that the proactive approach is better?
I agree with proactively engaging with stakeholders on matters of importance and relevance to the electricity sector.
Perfect, right. And I actually knew you would. So I wasn't trying to say that you don't or you should or anything. I knew that would be your answer. So are you concerned that we have a situation with an organization that when it comes to energy, we've agreed up front, is actually the constitutional, the statutory, the professional leader of energy management and energy development for Barbados, where in the boardroom, the only stakeholder currently represented is the capital investors. Does that concern you?
No, the boardroom has non-EMIRA board of directors, as I would have indicated yesterday and this morning in terms of the constitution of the board. There are non-shareholder members of the board, or independent shareholders on the board.
But, you know,
and I named a few of them yesterday.
Well, I saw the names, but Mr. Bach, you know that I was not really born in this century. You know. I was here in the last century. Mm-hmm. And the truth is, the representation on the board is represented by shareholdings. So if I'm on a board and I'm there because a shareholder put me there, I represent that shareholder. There's only one shareholder in Lightning Power. So I don't care what name you call. If Emira don't like what they say, that person is off the board next time. So I'm suggesting, would you agree with me that representation on the board is representation backed by shareholdings so that you are on the board to represent that interest whether or not other people like it? Would you agree with that?
The representation, yeah, the board is constituted with persons who representative of the shareholder, and the shareholder is selected persons.
And the shareholder is Emira.
Some of which are employees of the shareholder, and some of which are non-employees or non-EMIR members of the
And I suggest to you, all of whom are agents of the shareholder, on the point that they have been appointed there at the will and bequest of the shareholder. Full stop. But we don't need to argue that because that's a matter of point.
No. From a governance standpoint, the board, the responsibility of the directors is to the company, not to the shareholder. Even when you're selected by a shareholder to serve on our board, their responsibility is, your fiduciary responsibility is to the board, not to the shareholder.
Yeah, but there was, I told you he was born in the last century.
I know, I'm just telling you, as, you know, when we go through the training and elected to serve on a board, that, you know, is made clear that your responsibility is to review material, information that's brought, and it's to the company.
All right, so having said
Not to
that,
the person that's appointed you.
okay, let's accept that. Having said that, what assurance could you give the Fair Trading Commission, the other stakeholders, and certainly my members in the co-op movement, that over the last 11 years, having paid 85% of all income out as dividends, for whatever reason, that once this interim rate kicks in and the income increase by 10% or 5% of its half, what assurance do we have that the percentage payout of the income to dividends does not move from 85% to 90%, leaving the company itself in the same fiscal position as it is now? What kind of assurance is there for that?
Again, the percentages that you're calling are not really germane to the issues at hand. I've already indicated what criteria used to determine the issuance of dividends. And maybe they bear repeating: solvency, economic conditions, and the capital structure of the business. If we are at the appropriate capital structure we want approved by the regulator, then that will have an impact on the level of dividends that are paid. If you aren't, and corrections need to be made or adjustments need to be made, then that will have an impact as well, but not in isolation of the other two. It's a balancing act at the end of the day, and you need to take all into consideration. So the best answer I could give you is that we have identified the criteria that's used to determine how dividends are paid, and determined by the board, and those remain the criteria that will be applied going forward.
Well, I take your point, but I would like to point out to you and ask you to respond to my concern that those criteria that you just listed are all a bunch of totally subjective areas that are totally at the discretion of people making the decision in terms of adequacy of anything or the appropriateness of a capital structure. The closest one to being objective is the capital structure, and if you are going to suggest to me that the way to solve that, to bring the ratio down from 80% to 10 to 20 to 65 to 35 is to give away assets until it balances, I'm going to have serious concerns about that, and I'm sure you must have too. So when your expert comes, we will talk about that. But the point is, would you not agree that the criteria for making decisions like this should be objective, and it should be transparent, and all of the stakeholders should be involved in that transparency and in that discussion, so that the benefit that comes out is that people have trust in the decisions that are taken? Not that the decisions will be different, not that you would do anything differently, but persons like my members looking on would have a level of confidence that what is happening is being done transparently, it is in everybody's interest, it was the result of fair negotiation, rather than one particular stakeholder sitting in the room and purporting to represent the interests of 5 other stakeholders. Would you agree that that is a reasonable line of argument that my members represent in taking that position?
I wouldn't agree with that.
I would not have expected you to, so I get. But we feel very strongly about that, so that we can close on that. Just a couple other brief points. In 13, you said that, for example, that BLPC has been a strong customer focus and consistently engaged with various stakeholders and all that. And then you went on to set your strategic priorities. They are safety, clean energy, customer experience, and operational excellence. You recall where you outlined those strategic priorities?
Yes.
Now here's a little problem that we actually have. The government of Barbados also outlined their priorities. It's called the Barbados National Energy Policy, 2019 to 2030, a massive document. But if I were to summarize that into 3 key strategic objectives, I would suggest to you that 1, they want to move to 100% sustainable energy and away from expensive imported fossil fuel. 2, they want to do it in a matter of urgency, more aggressively than almost any other country in the world by 2030. And 3, and importantly, they want it done in a way that empowers a significant proportion of Barbadian stakeholders. What they call meaningful participation. So I just outlined to you what the Barbados government has identified as their strategic priorities in energy. Let me go back to the one identified now from the company. Number 1, safety. Number 2, clean energy. Number 3, customer experience. And number 4, operational excellence. In your mind, do you see this as a parent-child strategic alignment?
With the BNAP?
With the BNet, yeah.
Yeah, I don't see any misalignment between the two.
Your glass is completely different than mine.
Maybe.
For example, what is clean energy as compared, for example, to dirty energy or green energy? Because we did not understand how this fits into the government's 100% sustainable by 2030 plan.
You didn't follow how clean energy as a strategic pillar for light and power fits with the Barbados National Energy Policy of 100% clean energy by 2030?
Absolutely not. I don't even understand what clean energy means, so I was trying to get that understood.
Oh, but they both say the same thing. So, I mean, yeah, understand it is one thing, but to say that they're in misalignment when they're saying the same thing seems a little unusual. But clean energy in the context of how it's used in our case, would be renewable forms of energy, sustainable forms of energy.
So step 1 was to build the fossil plant in St. Peter, in St. Lucie?
Step 1?
Well, that's the Barbados National Energy Policy 2019 to 2030. Mm-hmm. In 2022, you're opening, well, you've been building it before. You're actually
it's
opening,
running, yeah.
Right, a fossil fuel plant.
Yes.
Admittedly more efficient than any of the ones that we had.
That's correct.
But it is not taking us towards 100% sustainable.
It is.
Well,
I explained the purpose of that plan. You know, this, I think, is an excellent question because it highlights the dilemma and the complexity in our sector. Here we have you making a statement or asking a question or calling into question the building of that fossil fuel plant, which is the very thing I was saying that made the decision as complex as it was even back in 2012, 2013. You have a host of other people in the room that are saying we couldn't have built it fast enough. So you're saying, we're out of step. Why are you building this plant when we have a transition to come to clean energy? And others in the room are saying, you should have built this plant already. You can't have it fast enough on the system. That in itself, to me, highlights the type. We are in a transition. It's a complex matter. There's been a lot of consultation with the regulators, held their own consultations, the government through the IRP process, us at different stages through our own IRP a few years back. And we've identified a path. The path that we've identified most recently with government leading the way on the preparation of that IRP includes the Clean Energy Bridge, which is a fossil fuel plant intended to facilitate the transition because we recognize that some of the renewables, and I mentioned some of it before, like biomass and waste to energy, which are baseload renewables, have not come about in the time frames that were previously anticipated. And as a result, we have to have some form of baseload firm capacity on as we make the transition, both to shore up the safe, reliable supply that is part of our reason for being and purpose, but also very critically to provide the resilience and backup that will be needed when the intermittent renewables that we're relying on are unavailable, either because it's overcast or at night. And so this plant, while it is fossil fuel, is saving on emissions, it's saving on fuel, it is providing an important baseload purpose in the absence of some other projects that haven't come on stream. And going forward, it is a bridge to renewable energy because it will allow us to manage the intermittence that solar PV, which is the predominant renewable we're relying on, will introduce onto the grid, or has already introduced and will continue to introduce as it grows.
Okay, I actually understand what you're saying, and you're not going to have any challenge from me about your response highlighting the complexity of the decision making that is required. As a matter of fact, that is precisely the point I was making and I got you to agree with when we started, when I spoke about the fact that if there is an entity in existence in Barbados with responsibility for conceptualizing, engineering, and implementing a successful energy future for Barbados, that entity is called Barbados Light and Power Company Limited, because that's where the expertise lay and the complex decision-making. In terms of your actual response, though, the truth is that plant in St. Lucie is what should have been built right after the last rate hearing, when this country was suffering from the inefficiency of the steam plant. Instead, nothing happened because of a lack of leadership. And I challenge you to suggest that leadership is not a responsibility of Barbados Light and Power, because nobody else had the expertise to do it. And you just outlined the kind of complexity that's involved. People were allowed to come and talk also nonsense about...
Mr.
Oh, that was a
Brown?
statement? Oh, yeah, sorry.
You're starting to testify.
Yeah, it's hard to avoid that someday, you know, Chair.
Yeah, right. So...
Question.
Yeah, get your question, you know, and how many more questions you have?
It's a lot. Mr. Chair, maybe...
All for Mr. Blackman?
Or whoever else you put there, sir.
But we have some others coming, you know, and Mr.
But sir, give me some time and I will...
How much time?
By tomorrow evening I should finish?
No.
All right, sir.
No. Mr.
So I'm going to wrap up shortly.
Yes. Yeah,
maybe 2 or 3 more items, and then because I will argue with Mr. Blackman outside afterwards.
Right. And make sure there are questions, and please refrain from testifying.
Yeah, okay, sir. Yeah, so point taken, but do you not think, Mr. Blackman, that it would be far more appropriate after the last hearing? I agree, and with the understanding that you made it clear, so I don't want to ask you to repeat this again, that the company did not give a commitment that they would install a plant. But part of the, upfront, we agree that part of the responsibility of Barbados Light and Power, or whoever holds that franchise, is to not only maintain the infrastructure, but to prepare it for our future. Capital investment, but we actually build lines in anticipation of load growth and things like that, or you all did. So therefore, the appropriate time for the clean energy plant, the efficient fossil plant, was early at the beginning or the end before the government's BNOP National Energy Policy came into being. But halfway into the policy, to be building fossil fuel, I am asking you to just reaffirm with me that you are comfortable that this is in keeping with the policy that the government has for 100% renewable by 2035 years from now.
Yeah, the plant would not have been required had the plants that were identified by government, waste to energy, biomass, those would have fulfilled the requirements that this plant, that was 60 megawatts. This is only 33. And the reason is not as much as 60 is because the sales disappeared. The sales were not there. Had the 60 megawatts been built, we would likely not be talking about this 33 megawatts.
So you're saying
that would be the clean energy bridge.
So I take it you're saying then that what the problem here was that government took over the role of Light and Power in doing that level of development planning.
I never said that.
Well, you want me to say it, and then you could agree if it's true or not?
No.
So it appears to us then, and you could tell me if we're wrong, that what happened in the period after the last rate hearing was that the company allowed persons who don't understand the complexity of what is involved to take control of the planning process, resulting in disharmony in the whole system. Do you agree or disagree with that?
I disagree with that.
You need to. So don't say any more, Mr. Blackman.
No, I have to say more, because the fact that you would say allowed gives the impression that we are in control of policy for the sector, and we aren't.
No, but you have a responsibility that you must enforce and insist on, and you have the FTC and the legal courts to do that. And you have a responsibility to Barbados to make sure that if you accept the job of leading the energy future of Barbados, then you have to accept it. And if it requires going to the FTC to enforce that, would you not agree that it is your responsibility to do that? If it requires going to the High Court to do that, would you not agree that it's your responsibility to do that?
Consultations, which we did, discussions with the regulator, discussions with government.
When that all fails, you go to the High Court or you go to the FTC. And you didn't, so, and you cannot
Mr.
escape. If you
Chairman,
accept the
Mr.
responsibility.
Chairman, can the witness please be allowed to answer the question before Lieutenant Colonel Brown starts to talk over him?
Yeah, Mr. Blackman, can we move on to investments?
Certainly.
This is, I think, number 14, you had actually, and this is probably, I'm coming to the end, so don't, you can tell your counsel to keep a low profile for me. You spoke of the key investments in section 14. And the first one was the AMI project.
Okay.
Just a couple of questions, and it's just a matter of you clarifying the points that you were trying to make. How does this actually, how does the AMI project respond to customer requirements? What is in this for the customers that it should be part of the rate base that they should pay for?
The AMI stands for Advanced Metering Infrastructure.
Right,
You may be more familiar with the term smart meters.
right.
So it's a form of smart meter. However, AMI goes beyond just the physical meter that is plugged into the socket base on your home or close to your home. It includes, importantly, underlying communication infrastructure that allows those meters to communicate with each other as well as the control center of the business. And in so doing, it's a productivity enhancing mechanism because rather than have to go out there and read meters physically, you now have the ability to automatically read meters in the field. It also, because of the communication infrastructure that's required to facilitate the AMI itself, I referenced or referred to it on Friday, I believe, as foundational investment in the smart grid. So the meter itself is a smart meter, but the grid, and when you hear discussions around smart grid, it really is infrastructure that's designed that communicates with each other and that can make decisions that don't require necessarily a manual intervention, smart decisions on the grid like auto healing and so on. So the question is, why would AMI be part of rate base? I think you...
No, what is in it for the customers?
What is in it for the customer?
Yes, right.
Is that it is part of grid modernization, which we hear a lot about and is mentioned in the application, as it is the underlying and foundation for the smart grid investments that will roll out on top of that underlying layer. So distribution, automation, I mentioned, automatic switches, potential for things like pay-as-you-go, which you've seen in the cell phone industry. In other words, you can pay in advance or prepayment for electricity. Those are things that facilitates. New types of services and products can be introduced as a result of the smarts that you're building out on the network. So that's a summary of that investment and what it looks like.
Thank you. But did it succeed in making meter readers redundant?
The AMI?
Yeah.
Yes, because you would yes.
Does it improve the accuracy of the meter readings?
The accuracy, no, it improves
Are customers any more assured that the units used per month are as more accurate than they were with the old meters?
Well, just add a little context. It doesn't, the accuracy of the old meters, our old meters are accurate, the ones that were replaced, just as these new meters are accurate as well. What it does do in terms of efficiency, though, is that it avoids the need to have to do interim bills and do estimated bills, because in the past, because of the constraints around physically reading meters, it was done less frequently. Now, with AMI meters, you're able to read at the same time, or more or less within a certain time frame every month, without the need then to have estimated or interim bills. So that's an example of the efficiency that you get.
Oh, which is really great for the company, but I mean, for most customers, stays through.
Well, it has been a point at customers in past surveys and so on. It's always been the interim bill, the estimated bill has always been a point of concern for our customers. At least that's the feedback that we've gotten. So through the deployment of these meters, we'll be able to address
Okay,
and
thank
respond to customers' needs in that way.
Just two other brief concerns that you could probably just speak briefly about to relay some questions that came up. Customers have been advised about the level of intrusion that these meters bring, the extent to which the company is now able to access information about usage, being at home, the time of when they're up at night and all that. Have customers been advised about the level of intrusion that these meters come with?
I wouldn't frame it that way because we don't want to send a message to customers that there's an intrusion on them with the deployment of the meters. What we have done at various times through the deployment is share with customers what the meters are, generally how they operate and communicate, and the benefits, which I've just explained here, of having those meters in place. And some of those, as well as some of the services in the future, which we discussed on Friday, would be things like customers being able to, better sense. The meters can give customers information as well. And those are things that we're rolling out and developing over time.
Okay, thanks. I had one other thing on the meters, but I suspect the chairman is not going to let me pursue it. But I will just briefly tell you that one of the concerns we had about the AMA is that our assessment of what's happening at would you say that Light and Power is currently billing customers for the actual service it provides? And let me explain what I mean by that. Right now, you bill customers for energy, largely for the number of units used multiplied by the cost per unit.
And demand in some.
And demand in some cases. But essentially, what you sell is a far more complex entity. You actually sell reliability, on-demand access to power, consistent, as established by the FCC, those standards of service, frequency, voltage standards. So at any time in a month, a customer has access to a high-quality service, electrical service, but what you bill for is the number of units used in that month. So that, for example, a customer that this is the question, sir. The question mark coming at the end, sir. So on a particular, the first of the month, a customer may use 400 units by whatever means, and not have access to power for the rest of the month. A second customer uses 400 units over the whole month, but has access to power for that whole month. What would be the difference in your bill?
For a demand customer, the one that used it over a shorter period would have a higher bill because they would have a higher demand in order to use those.
No, the demand is the same.
No, the demand is not the same.
No, the other fellow may use 400, the standard two, and just have available for the rest of the month. The point is one has it available and the next don't have it available. So let's say it's the same demand.
Then your scenario wouldn't work. If it's the same demand, then they can't have the same units over different periods. Because the units are a product of the demand and the time that demand runs over.
No, the units are a function of the usage and the time.
Yeah. Units are a function of the demand
the actual
over
units used and the time
units,
that is used. Yeah.
Units used are the product of the demand by the time that demand was applied over.
Anyway, I said I'm not going to pursue this, but this is something that we will argue about outside. But the point I want to make, and I want you to confirm this, that those AMI meters has the potential to move us to a point where you actually bill customers for the high quality service that the company provides. This has implications for the whole energy future going forward, I would suggest to you, and it's something that needs to be pursued, but has been completely ignored in this rate case in everything that we hear coming from the company. So that's something that I would like us to pursue at some point.
So, Mr. Brown, if you could be better served if you could direct that question to another person in the entity, because I don't think the witness understood fully the question that you were asking.
So I agree to move on, sir. I take that guidance. You said, that in 2016, the company constructed a 10-megawatt solar farm in Trent, St. Lucie, when it determined that utility-scale renewable energy plants would be economically viable in Barbados. This is in 2016. Don't you find that a little bit arrogant? That the company decided that a utility...
Objection argumentative.
That's a question. What's the argument about that?
Objection argumentative, Mr. Chairman, you can rule.
But tell me what that's the argument is, Mr. Chairman.
Council,
In terms of stating that it was an arrogant move by the company, sir, that falls within the
asked a
classical
question.
definition. Even if it's a question, it is argumentative, Mr. Chairman. That's the basis for the objection.
okay. Mr. Brown, could you rephrase?
Do you think it's best public relations to assign to the company the singular right to decide that it is going to install a utility scale renewable plant because it's economically viable? The question is, what did the other key stakeholders think? For example, does BLPC have a license from the Ministry of Energy to install that plant? What does BNOCL think? Because according to my understanding,
Mr. Brown,
Chair,
Mr. Brown, could you
question at a
allow
time?
the witness time to answer a question as opposed to giving him all of the questions unless you're introducing a multiple choice question in which you'll ask him to select A, B, C, or D?
Chairman, in addition to multiple choice questions, there are multi-sector questions.
Well,
But if you just want to say one, if you just want one thing,
allow the witness
Mr.
So,
Chairman,
and
I just try to be
allow the
expedient with time
witness
for you.
to answer a question at a time.
Not a
Mr. Brown,
problem,
that's
sir.
all we're asking.
No problem. So what did the Ministry of Energy think about this plant? Did they issue a license for the construction of the plant?
No, the plant was built under, or I'm afraid to use the word license after the previous thing, but the plant was built under the existing franchise of the utility.
Okay, so let me tell you why I don't understand about that, and then you tell me where I'm wrong.
Mr. Brown, I would also like you to refrain from asking the witness what the ministry thinks, because he is not in a position to answer for the
So you asked if you
ministry.
got a license, so that's not thinking thing. You either have a license or you don't have it.
No,
No, you asked me what the ministry thinks.
so just ask the witness questions that relate to the Barbados Lighting Power and its application.
So and he was asking, I asked and he said that they didn't need it, so they don't have one. They have one already. Are these intermittent plants not energy producers? Don't these plants produce energy?
They do.
Is not the role, the energy sector of the Barbados electricity market, the purview of the Barbados National Energy Company Limited?
You're confusing me now, because you were talking about leadership earlier, and now you're criticizing us for building a plant that is in keeping with clean energy goals and objectives of the country.
I was talking about leadership before, and now I'm talking about roles. So
Right.
there's a role that BNOCL play in the energy market. They actually import, store energy.
Or you're on a
They
B-
transfer it to you, you convert it into electrical energy, and you distribute and sell it to customers. They are clear, distinct roles. The question that we have is, and we're asking for your clarification, is there not a crossing of borders when the company that is there to generate and distribute gets into the energy part of it?
But it's all
If you're
energy.
are you comfortable with that, or do you see that there's a discrepancy?
If you could state the question for me, because
In the Barbados electricity sector, there are largely two components to it. The BNOCL import fuel, store it, and transfer it to Barbados Lighting Power Company. Is that correct?
they are one of multiple importers.
Well, whoever, so they're importers, but you don't do it because the fuel charge just flow through straight to customers. What Lighting Power bills for is when the fluid goes into the machines at Spring Garden, becomes electricity, you distribute, sell, and that is your component. The question was,
Bill for both.
are you not going on the other side of the fence when you get involved in renewable generation of energy?
Miss-
That's the question, Mr. Chairman.
Yes, it is a question, but it's irrelevant to the rate hearing.
But I'm responding to I will leave that to one of the other technical experts, Mr. Chairman.
And
That's actually one that I have technical expertise in.
But I know that very well, I can't think of anybody else in Barbados that can actually answer that for my benefit.
So the answer is no, is generation of electricity.
Okay, thank you. Well, Mr. Chairman, since I seem to be causing so many problems, I have a couple other questions here, but what I will do, I think I will reserve these for the other person to give Mr. Blackman a chance, and in case he comes to visit us again, if there's something that is not clear, I will pass it on. So I thank you for the opportunity, and I will close out this point.
Yes, and thank you very much, Mr. Lieutenant Colonel Brown, for your cross-examination. So, Mr. Wendt, are you prepared to do your cross-examination at this time?
Mr. Chairman, thank you very much. I was not prepared. I was prepared for a long time. I was struck off guard because I could not believe that the applicant for something that was written within the application at page 15, where the reasons presented for not implementing the steam plant were going to be seen as something foreign. So what I've done, Mr. Chairman, is send an email with the exact references from the application of the company for all the points that are going to be raised around the steam plant. And I'll make it, I really appreciate the time that I would be able to send that out, but I didn't think we would have come to that. This steam plant matter has been going on around Barbados for too long. The approach I want to take with Mr. Blackman, which I'll address him shortly, is that we want to first get the fact that Lighting Power had planned to install new plant to replace the steam plant and was going to do by a certain time, so that by 2012, that we would have been able, as ratepayers and the country saving the oil, would have been able to save $30 million. And I think I've sent it around to everyone. I can read it if you want me to, I will.
Ms. Wendt, I just want you to raise the questions to the witness.
Yeah, and I will do that now. Mr. Blackman, I have before me here testimony that says, from your application, am I correct that the steam turbine generations were installed in 1976 and were scheduled for retirement in 2012 as indicated by the company during the last rate review? Is that correct?
That is correct, yes.
Right. And it says that as the, so on the next one, we estimate that the new plant would have saved Barbados $30 million in fuel by being able to install that said new equipment, which will use not only less fuel, but also less costly fuel. And that is exactly from the 2010 depreciation, page 49, paragraph 190. Is that correct?
I am not certain.
Could you have someone check that? Because this is the basis for which this whole presentation on the steam plant has to be made. And Mr. Blackman,
read it again,
you could, I'll go slowly. If you go to page 49, paragraph 190 in the 2010 decision, it indicated that the same new plant that was mentioned in the application was estimated would save Barbados $30 million per year in fuel by being able to install that new equipment, which will use not only less fuel, so the equipment itself is going to use less fuel, but it was going to be using less costly fuel. So we were going to get it on less volume and at a lower rate, which is why then the analysis was, I think some analysis might have been done by your financial control at the time. But the basis of the presentation on the steam plant, we have to be grounded in these matters, because this is no longer now about the nice things about it. I want to get straight to the bottom of the 30 million that we should have saved and the timelines. Yeah. We've already established that you commit that we did not order it in 2009, which would have had it ready by 2012. We did not order it by 2010 to have it by 2013, or we did not, or it wasn't ordered by 2011 to have it by 2014. And what that would have meant at that time, that was every year we don't install that plant,
Chair,
both,
could you
no,
possibly
Mr. Chairman.
describe the,
Mr.
ask
Chairman,
the
no.
intervener to ask a question of the
Mr.
witness,
Chairman,
please?
no. We stop here and hear Mr. Worm ask because you liked it, and we hear everything. You're not going to stop me. Mr. Chairman, we have to ground these things carefully. I'm saying to you.
But Mr. Worm, all we're asking is that you ask, Mr. Vent, sorry. Mr. Vent, all we're asking is that you ask Mr. Blackman a question, that's all.
But
That is all the request is, that you ask the witness
Okay,
a question.
okay.
Because we cannot allow you to
Okay, I'll go ahead.
testify.
Okay, no, they're not testifying. I wouldn't do that. I just
But
want.
just ask
Let me ask you a question.
a question.
So, Mr. Blackman, then, are you saying to me, so you are in agreement that the company then, having not ordered that equipment, both in 2009 to get it ready for 2012, or in 2010 to get it ready for 2013,
But
are you
Mr.
saying to me, Mr. Blackman?
Mr. Vent, you asked that question earlier and you established the timelines. You went through and you asked about January, June. You asked the question and it was answered. Could you move on to another question?
I will take your guidance, Mr. Chairman. Okay. So here we go. What I want to get from you, Mr. Blackman, is for all the reasons that you have given why an employer did not change the plan. When I first started this, you were unclear, and I assume I would take it. I don't think that you meant to be dishonest or anything, so I would take it that you wouldn't recall. But at page 15 of your application, one of the reasons given in part guided by the recession which began in 2009. And don't say the wrong thing because I'm not here to do that. Go to page 15 and tell me if what I'm quoting is correct.
Page 15 of the application.
Page 15 of the application. You will see there that part of the reason was in part guided by the recession which began in 2009.
Oh, I see it. The
You
decision
see-
by BLPC to extend the life of this team was guided in part by the
Yeah.
continuing
Yeah,
recession which began in
keep that
2009.
page open. So let's deal with
Have it
that
open.
first.
Related flat sales.
Yeah, so we can come to sales. I tell you, we can come to all. You don't worry. The first thing about that 2009 recession, we agree with you that recession, and I presented testimony started in 2008 in the US and the UK and elsewhere. So, Mr. Blackman, would you agree then that the whole basis of not retiring that steam plant cannot be because the recession was around then? Because we all would have known that that said recession would have been there.
Yeah.
It cannot be a reason why you then haven't said, since knowing the recession started in 2008 and commit to implement the plan in 2009, the same recession would have been there.
The related sales, if you continue.
No,
reading-
I'm going to sales. I'm telling you, the
No, but-
first thing I have to dismiss, because I'm going to dismiss each one of these,
Okay.
one after another. The company would have known that the recession started in 2008 in the US, and therefore, it cannot be a reason for you not replacing the steam plant, because you already knew that when you give the commitment to replace it.
You cannot look at a single factor in isolation.
But I'm coming at all of them. I know you're...
I'm saying it doesn't make sense.
Mr. Vent, you've asked the witness a question, allow him to answer the question and try not to argue with.
Mr. Chairman, with the greatest respects to the witness, I don't want to come in here and ask why the air conditioner is on and you tell me the grass is green. I said every single reason that is given, Mr. Chairman, to the witness. This is to the witness. I am going to answer from related flat sales to anticipated rapid transition to renewable energy to the IDB. I want to address them individually.
Yes,
So-
and so
the
question is, you're asking him if inflation was
If-
a reason.
Right. I'm saying to him that The recessions.
You're not saying to him, you need to ask him a question.
Okay.
So you need, not that I'm saying to him,
No.
you need to phrase it so that he, as a question, so that he can respond based on the question. So don't say to him,
Okay.
ask him. So for example, is inflation a reason for you to have deferred the installation of the steam plant? That is a question.
Okay. So, Mr. Chairman, let me go to Mr. Blackman again. Mr. Blackman, are you aware that the recession was in 2008, started in 2008?
I'm not sure when the recession started.
Okay, well, I provided you with a link to tell you, to show you that everyone would have been aware of the subprime, the recession of the financial sector that hit the entire world. And I don't want to play these games.
That's noted, but we're talking
Right,
about...
but I'm asking a question now.
Okay.
Would you have been aware that that recession, the company would have been aware the recession started back then?
Yes.
So then, in your testimony, and having committed to install the plant in 2009, can the recession then be now used as a reason, one of the reasons why you did not install the plant?
Most certainly.
When you were aware of it in 2008-9,
Yes.
and you commit to install it, but at that time?
Yeah, the reference here is the continuing recession.
No.
A recession having started doesn't mean it will go on forever. Obviously, a continuing recession that is has an outcome of flat sales is a factor, yes.
Let me go to your facts.
And the point that the recession starts is immaterial. The ongoing nature of a recession is what you have to take into consideration. At some point, it should end. But once you have a continuing recession, as highlighted here, you cannot ignore that when you're planning the expansion of the electricity network. I have to take the prevailing conditions, regardless of when they started, into consideration.
Mr. Chairman, I believe the board is wise enough to see that the decision not to install this same plant either to get it ready by 2012, 2013, or 2014 cannot be because of the recession. So let's go to your flat sales that you wanted for a while. Now, what was your customer base? And again, this question is related to your flat sales on the same page 15, because that's one of the other reasons you give. Mr. Blackman, what were your customer base like in 2008, 2009, 10, 11, and 12? And I have all the annual reports here, so
Well,
if you want them, I can give you.
But you provide it, because I'm not sure when you say customer
I'm going
base.
to give you.
mean
That's why I'm
numbers.
trying to help that we can get this proceeding, because I have a lot for you. And the questions that you can answer, I don't want to give to your team. I'm trying to be as nice as possible. So in 2008, at page 51, your published accounts, you had a customer base of 118,798 customers. That increased year on year. If you go to 2009, it was 120,622 at page 61. If you go to 2010, it was 122,106 at page 68, and they're all here, you can lend your mind. If you go at 2011, it was 122,899, and that was then on page 14. And in 2012, it was 124,094. So, having showed that the customers were increasing, and that plant was to be committed to install from 2019. Mr. Blackman, could you say that there was flat sales at that time?
What were the sales over that period, Mr. White?
I'm telling you that the customer base has increased.
I heard you. What were the sales over that period?
You tell me.
But
I'm saying that the
so
plant.
experience, you must have it in
you
front
tell
of
me.
you there. Sales and customer numbers are two different things. Because you have more customers does not mean you have more sales.
Will you tell me what the sales were?
All right, let me look for. in the interest of time, is it okay if I get someone to,
Yeah,
maybe
you
from my
could,
legal team
you
to
could
put-
provide it
to
another
put it-
time. We got a
just
lot
let
to
me
go
know where
through.
it is.
But I'm submitting to you, I'm saying to you that the growth, I've shown you that the
So
customer was
let me
growing.
answer it in terms of
Yes,
and
sorry,
dollars,
go
because I
ahead.
think the question came up this morning, and you're asking from 2009?
No, and because the plant was supposed to be installed in 2009, and I granted something could happen, you didn't get it in 2009, I would have expected 2010 or 11.
So
But it's
basic,
$30 million a year.
would you be happy with basic revenue as a proxy for sales in terms of revenue from
Yeah,
basic
but you could,
sales?
if,
So in 2009, it was 201 million?
just one sec, let me pull up my numbers, I don't want.
This was in response to your interrogatory, or W12, I believe this was May 3rd. The numbers are in the response to your interrogatory.
Yes, if you proceed, please.
So you're asking me what sales were in that period, 2009 to 2012?
No, I'm saying to you what the customer growth was, and you're saying to me that you want to give in the key, you didn't had, you said
No, I
that sales are
accepted-
different
I
to
accept-
revenue, and I agree with that. You want to give me the revenue as an indication. I said, well, I'm a nice man, I will take those.
No, I accepted the numbers, even though I haven't checked.
No,
it. You
but-
have-
but-
I trust that you're reading the
No,
numbers from the
rest assured.
application. And what I indicated, I wasn't offering any, I indicated that surely you recognize that numbers of customers that do not represent sales.
And-
You can
and-
have more customers and still not have sales.
And I've told you, bring me the sales numbers, and you said to me, if I can take revenue, and I said, well, I'm a nice man, I will take the revenue, it's the best you can do now.
Okay, so 2009 to 2012?
Yes,
Basic
please.
revenue in 2009 was 201 million, roughly, rounding up to the million. In 2010, it was 202. In 2011, it was 193.8, 194. In 2012, it was 193.19, so 193.2. In 2013, it was 191.9, falling further, 192. And it continued to slide steadily. 2014, it was 189. 2015, a slight bump, 191.
Oh, no, 2012 is enough for me
Or
because.
2012, so steady
No.
decline between
No,
2009
let me show you the numbers that I have.
Okay.
The numbers that I got from your statements tell me, yeah, that you had total income of 473,000, and then you can deduct the fuel charge of 473 million. We had, because I haven't got time to deduct it. So the numbers here from the financial statements you give me were 415 with 501 at 101 as the fuel charge. And I'm putting it to you that if I deduct those numbers now, you had growth in those years. So we're not going to debate that. All you have to do is bring me the sales that you said you will bring so that we don't got revenue. Because I simply want to take your total revenue and take out the fuel charge to see what is the rest of the revenue that accrue to the company. Because they expect that the fuel charge will be the equivalent on the expense because of pass-through.
Maybe the
The
sales.
point that I'm making to, yeah, go ahead,
I can
sir.
give you the kilowatt hour in sales maybe before, just to get it out of the way. If someone on maybe the lead team could direct me to where we have those sales in the, because it's straight, this is a fairly straightforward matter. And the sales would have been, I mean, it's not directly with revenue because of the different tariff blocks. But I'm able to show basic revenue from sales over that period that you've asked for declined over that period.
Mr. Chairman, if anybody could assist Mr. Blackman and give him what he wants, I would be happy.
Mr. Blackman, could you just project the slide that you had before?
Sure.
And just scroll slightly to the other way.
This
right?
way?
Right.
So this is
so that we see just scroll that we see the label. The
Oh.
other way.
this way.
Go
You're
a
not
little
seeing it?
further. No, we're not seeing it.
Oh, I think that is probably,
Anyway,
that's the IT.
we saw it just now.
If I move it over here.
Well, open.
Hold on, yeah, okay. So I can't use it full screen, but
Right.
maybe that does it.
Okay. Yes. Just Right, okay. Right. So, Mr. Wendt,
Yes?
I think what Mr. Blackman is trying to explain is that when you look, just scroll down slightly for us. Right. That when you look at the total revenue, that the total revenue is made up of different components.
Yes?
And that you have fuel revenue included in there, which is a direct pass-through.
Yes?
So if you note during that period that the fuel revenue was increasing, which would have contributed to the total revenue for the company. However, that total revenue of, let's say, 509 in 2010 compared to 415 in 2009, at the same time, note that fuel revenue increased by almost $100 million. So what he's trying to explain to you is that the basic revenue is the one that you should pay attention to and not the total revenue.
So I'm in agreement with you, Mr. Chairman. You couldn't have put it better. But what I'm saying to you is from the non-consolidated financial statements, in 2008, the revenue was 473,310, and the fuel charge was 117,230. That means revenue at the time was 356,000. When we come to 2009, the revenue was 415,000. The fuel charge dropped to 101. That was 313,000. Million. I mean millions. But when we get to 2010, that revenue is now 389 million because the 508 minus the 118 which increased leaves us with 389 million. So over the period 2008 to 2012, revenue outside of fuel was 356 million in 2008.
Chair, the witness is totally misreading the document that is
No,
before us.
no.
And I know he's entitled to his interpretation, but the
No.
numbers are the numbers, and I would suggest that the commission, having them before them, having been filed, the assessment can be made as to whether the witness's interpretation is correct or whether Mr. Blackman's interpretation is correct. But to continue this line would just be wasting time.
No, Mr. Chairman, the last one you should talk about wasting time. You interrupt the people all the time, and we're here. We didn't interrupt you at all. Don't let's get hot in here. We want this to be a nice, possible, sweet area. I'm saying to you that the audit financial statements that you all give me, I've got the audit financial statements. You can take time and go through each one, because I'm not giving up on this. Your revenue only dropped in 2009, but in 2010, it was 389 million compared to 356 in 2008. In 2011, it was 476 million compared to the 389 in 2010. And it was 466. So your revenue has been climbing in general. And once I deduct the fuel charge, all these numbers came from the audited financial statements of the company. So the point that I'm making is, it cannot be, right? And I leave the commission to determine this because I'm going through every one of these. This is not no of giving general and nice words. We're going at the evidence.
Okay,
Mr. Chairman, I'm asking the witness.
Mr. Wendt?
Yes? I'm asking the witness.
I understand,
sorry.
but in terms of your analysis of the information, when we do publish financial statements, it would just have aggregates. So what the witness has presented on the screen there for us to examine is a better indication of what actually made up that revenue. Published financial statements would only refer to aggregates. So if we could look at the information that the witness have presented there to see what is happening in terms of basic revenue versus fuel revenue, miscellaneous revenue, investment income. These are other components of the total income. So when we prepare the published financial statements, you would just see total income. So to simply deduct the fuel expense and assume that all the rest is basic revenue would be an incorrect process. So just bear with us in terms of recognizing, yes, that when you look at the published financial statements, it will say total income. because we would aggregate for the purpose of publication.
Mr. Chairman, I will move on, but these statements are not from these information is from the non-consolidated financial statements that the
Yeah.
company provided.
Yes, and that is,
Okay.
yes, and I'm just saying is that when we prepare
Right.
consolidated financial statements for publication purposes, those statements would be aggregated. And the evidence that is being presented here is more useful for you to examine what is actually happening in the company in respect of the various components of revenue. So we do understand they're audited financial statements, but they are prepared in an aggregate form for the purpose of publication. And that is standard using the International Financial Reporting Standards.
Mr. Chairman, let me just finish this matter, please, on one matter. I have before me large power, secondary power, domestic service, general service, street lighting, time of use, miscellaneous. This information was all provided by the company. And all they've done in aggregating that revenue is to be able to say, leave all those, whether they're large power, secondary power, domestic, whatever. The only thing that they've done is to remove the fuel charge. And I don't, and my main argument is that I do not want to come here and leave the impression that a steam plant was not installed because back in 2009, back in 2010, 11 and 12, when that plant should have been installed to save us $30 million per year, we're saying that sales were flat and that the place was coming in. That was not the case. Not, but it might have happened later. But at the time when that plant was supposed to be installed, that could not have been an issue. And that's why I told you in my presentation, both the commercial value of $30 million per year for the repairs in the country, as well as the timing is critical.
Mr. Wendt, you are again testifying. You would have made the point, and it is, the witness have not denied that the steam plant was not commissioned as planned.
Well, let me,
but he have that, so we would like you to move on, you know, to...
But, Mr. Chairman, the witness gives specific reasons why they did not install the plant. I have to look at every one of those listening. If I was with Sahar St. John now, he would say, but Ricky, unless you look at all of those arguments that are there, and we're going to look at all of them, then I can't take it anywhere. Because what I'm saying here, Mr. Chairman, and this is for discussion for later.
I wouldn't consider that my friend is comparing himself to Sir Harold. But Sir Harold certainly would have indicated to the commission that Mr. Wendt is entitled to his interpretation of the information. The witness has answered the question as asked. The commission has the documents. There is no need to go over the same information again.
Mr. Chairman, I'm going to let Mr. Ramon Allen present my information because it seems that he is better placed to do it than me. I'm going to the next issue that was raised, that was why the company did not install the same plant, is because the anticipated rapid transition to renewable energy. So I've covered first the guided by this recession. I've covered these flat sales. I'm now going to the anticipated rapid transition to renewable energy. In the company's testimony, and that is in its 2010 decision on and I'll read, during the 2009 rate hearing, BLPC explained the applicant intends to install a new plant that is efficient and which is of the lowest economic cost to the country, such as medium-speed diesels, which will be able to operate on heavy fuel oil and be suitable for natural gas operation if and when it becomes available. Quote, the company added that the applicant is considering a wider energy portfolio, which includes renewable energy. That was in 2010. Mr. Blackman, I've told you what the company committed to. Would you agree, or are you aware that the company, as far back as 2010, had a plan for renewable energy to be involved as part of the portfolio of the generating plant?
Yes, in fact, we introduced the renewable energy rider to facilitate customers themselves
Right.
contributing renewable energy.
So, Mr. Blackman, would you then agree that the idea of renewable energy being one of the reasons that had to stop purchasing the new plant can't be a reason to stop the customers from reaping $30 million per year and the country saving $30 million in fuel? Then back in 2010, you wrote that part of your portfolio mix is renewable energy.
That is correct. But
Let's move
I
on.
already explained that 60 megawatts of renewable energy, as announced, is rapid and would have, we wouldn't be having a discussion even on the Clean Energy Bridge now.
Mr. Blackman, I ain't coming to your 60 megawatts.
But that is the rapid
No, but I'm coming to it.
transition.
If you have any fear, I'm telling you, I'm coming to it. We have gone through, one, this recession, we've gone through the flat sales, and we've now gone through this anticipated renewable energy. Next, we're going, if you want me to go to Cahill first, I can. But I would like to go to IDB first. IDB, you mentioned IDB, had a renewable study.
Where are you reading it from?
This is now, in your testimony, you say that part of the
Oh,
consideration with the IDB study, is that correct?
I use that as an example.
As an
of a
example.
policy that predated the current policy.
Precisely. So you're correct that IDB renewable study would have influenced planning. So given the insistence of this urgent need to order new plant in 2009, even say by 2010, I send you documentation that says IDB pointed out at that time, back in the 15th of September 2010, that Lighting Power had at the time, it says 239 megawatts of installed capacity, predominantly used fossil fuel. But the 33 megawatts would only have been 33% of that. That same study said, Mr. Chairman, Mr. Blackman, that irrespective of IDB, it says here that in event back then that government's policy would have been supported by the installation of an efficient fossil plant such as municipal diesel unit. That is what that study said. So the study acknowledged, which you quite rightly explained to Mr. Brown, that the diesel plant, medium speed diesel, has to help when the rain is falling or is at night or whatever. So we're not disputing that. But it cannot be that policy that would have stopped you from installing it. Would you agree that you are aware of the IDB study?
I am, and it's not the policy in isolation. It is all of the factors you have read so far in combination.
That stopped you from installing the steam plant, replacing the steam plant, ordering to replace it, that we would have had $30 million US dollars, 30 million Barbados dollars?
And the others that you're going to come to next.
Yeah,
Yes,
I'm coming to them.
Correct.
Because I'm
correct.
coming to all. So, Mr. Chairman, what we've established is that back then, the government says we recognize that
Chair,
part of the
Mr.
fuel.
Wright, stop
Man, you're not
summarizing
going
what
to
he
be here,
believes
man.
he has proved and yet to question in the witness.
Mr. Chairman, I've asked the witness if he was familiar with the IDB study.
I am.
And I'm saying to the witness, that study,
But, Mr. Wendt, we've allowed you to examine the witness, and what we would have obtained from the witness is that the steam plant was not commissioned, and if the steam plant was commissioned, the fuel would have been reduced by 30 million a year. All the variables that you're asking relates back to that same point. So I think the witness has agreed that having not purchased the steam plant at that time, they were not able to achieve the 30 million in savings. So to ask him every single item will still lead to the same answer, that the steam plant was not commissioned, and we therefore did not get the 30 million in savings. So it's not necessary to ask him 12 questions on the same point, because he has answered the question. So unless I'm asking you if you have something other than the 30 million related to the steam plant to move on.
Mr. Chairman, we are going to come back on this same steam plant because I said to you, you cannot come in this forum and present a general memorandum that given reasons why you don't make a decision, and those reasons are not critique. Mr. Chairman, you heard that's why I told you timing and commercial impact is critical. Mr. Blackman, did you mention that the Cahill Renewable Energy Plant was a factor?
I don't.
Did you mention that the 60
megawatts of waste energy
Yeah.
and biomass? Correct.
Did you know that when that Cahill project came on stream?
It never came on stream.
No, well, when it was supposed to come on stream. Do you remember the year? Well,
help me. You tell me what.
Let me help you.
Yeah.
The same study referenced that was coming. Cahill referenced it as well. And on top of that,
Which study?
the same ADB study, and I'm going to really
Reference Cahill.
provide the information to you because I didn't want this to happen to me again. All that I'm going to hear from you have. And you have the right to, when you're going to read it, to come back to me. But it says, in the report, Cahill said, reference is made to the UNDP development program of achieving sustainable ends for all small energy development states, a conference that was held in Barbados in May 2012. It was sometime thereafter that concept Cahill Energy Project contemplated. So that project was contemplated after the CIDS conference in 2012, which means that Cahill could not have been a factor as to why you did not install that plant between 2009, 2010, 2012. Is that correct?
Not sure about the dates, but remember we were talking about a period from 2010 to 2020.
I will come to those if you want me to.
So the timing, I mean, all of the factors I've given are factors that influence the decision. The plant could have been installed at any point during that period, and Cahill was most certainly a factor. The 60 megawatts most certainly a factor.
I agree with you, the plant could install any time, but you came and give a commitment you want to save the country $30 million, and you said one of the factors that stopped you from doing it is Cahill in 2014-15. I was one of the people, we went to Lloyd Erskine and fought Cahill.
Mr. Wendt, you cannot testify.
No, but we have to put the facts here, sir.
We're asking you to cross-examine the witness, and I indicated to you earlier that the point related to the steam plant has been made, and I'm asking you if you could move on. I am certain there would be other questions outside of this that you could ask of the witness. I'm asking you to kindly move on.
Well, I just have one last one, Mr. Chairman, and I will move on this steam plant. Mr. Blackman, you've also mentioned the delays, approval of town and country planning, and I would agree with you. That is the only reason that I have seen in all the evidence, all that I've read, for the period you had to install that. And the reason for it, I've given you testimony that shows. There's enough around to show that very often, you know, approvals, all of us get hurt by town country
Mr. Wendt,
planning.
the question, please.
Mr. Blackman, did you make any requests to the town and country planning for the approval that says, could you give us any correspondence to show you let them know the approval of this will save the country $30 million, and you persistently go at that and you still didn't get approved? Do you have any correspondence you can share with us?
Not like that, no. We wouldn't have gone into the things like dollars and savings, no.
Because, oh, okay, maybe for another time, because this is frustrating. So what we have established, Mr. Chairman, I'm moving on to this questioning. I want to move from the steam plant. But all of the reasons, the only thing that I am seeing that should have stopped the customers from benefiting for $30 million a year, and the consumers for that steam plant not being, and to make it worse, we're now got to accept that in 2022, the same clean energy bridge come that save us the same $30 million.
Chair, could you advise intervener Wendt that we are not here for his final submissions,
Well, that will
early
come.
submissions,
But that will
or
come.
partial submissions,
No, but that
and
will
to
come.
ask a question.
Let me ask the question then. Let's go to the Clean Energy Bridge. Let's go to the Clean Energy Bridge. And I knew it was going to get like this. It's not theory. No. In your submission, would you agree, Mr. Blackman, that the Clean Energy Bridge was not part of your depreciation study, the one of 2019 or the 2017 study or the updated study in 2019?
I would agree.
Right. What factors would have been different now that would have led you, for example, a number of things, what factors would have led you now to decide that you are now going to implement this Clean Energy Bridge?
I believe I answered that earlier.
Well, you just answer for me again. I might not be as sharp as these
It's not the
guys.
purpose, Chair. If it's been answered, it's been answered. Mr. Wendt was here for the full proceedings.
Mr. Chairman,
This is not repeating questions per
I
intervener.
want to get an understanding because and I'll tell you why. The next question then, if you don't want to repeat them, fine. If you're a lawyer, he's being paid. What factors that are different now for the Clean Energy Bridge, the medium speed diesel, that would not have been the same back then?
I answered that earlier as well. The same question was asked earlier.
No, but what would these reasons be?
Well, there was certainly,
Apart from we lose $30 million a year.
Mr. Wendt, could you allow the witness to answer the question that you're asking?
yeah. Well, one for that matter is the conditional approval to build the planning approval. But also, as I mentioned earlier, there was broad agreement across the board, stakeholders, policymakers, about the need for that fossil fuel plant to provide base load capacity while we pursue renewable energy, which was running behind what had been anticipated earlier on. So projects like the ones we mentioned earlier, waste to energy, there was biomass as well, incidentally. It wasn't just Cahill, there was Andrews, you might recall. All of those projects were somewhere in that period, 2016 to 2018, that sort of time frame. And it does take time to develop a plant like the Clean Energy Bridge. A lot of that development work, you yourself correctly pointed out, had actually taken place and started in 2010, which meant that, but we wouldn't execute on it unless you had some form of, unless there was alignment, and those factors that I identified previously were addressed. And big ones that would have changed would have been that general alignment across the board, including with policymakers, of the need for more fossil fuel, even though there were calls about 100% renewables. And the reasons for that is to provide that resilience, that base load capacity that is necessary.
Sure.
And the backup beyond 2030
Sure.
that will be required to support the transition to renewable energy. So those are some of the factors.
So, thank you for that, Mr. Blackman. So you could rest assured you would get all the support from me for eventually installing a medium speed diesel engine, which I was pleased to see about some question. Let's look at the life then of that Clean Energy Bridge. I probably should leave that for Mr. Hulk, because as I said to you, Mr. Blackman, I'm not here to give you questions. The whole question of the life and its estimation, I leave that for when Mr. Hulk came.
Well,
if you,
he's not
if
an
you,
engineer. I mean, all right. Well, it's not.
did he not do the life study?
He did the depreciation study.
Yeah, well, and so I want to get,
but
he
the
was
life-
involved with the life of the plant at all?
Yeah. So the life of the plant was
Yes, go
determined
ahead.
based on the asset itself. So yes, specific questions in relation to depreciation, absolutely.
I'm talking about the life. I'll get the depreciation, but he was involved in the life of the plant at all, any consultation?
Yeah, we would have indicated to him what the life of the plant would be, and he used that in his assessment and study.
Wait. I want to be clear. The life estimation, like when I have Dr. Alfar coming, he does life
Right.
estimation.
Yeah.
I am presuming that Mr. Hulk is the equivalent of my Dr. Alfar. Are you saying that, I'm asking, did Mr. Hubb had any involvement with the estimation of the life of the Clean Energy Bridge?
The estimation of your life, not to the best of my knowledge, no.
Okay, well, let me bring these questions
And let me
to
just
you.
correct, sir, I said it wasn't an engineer, I meant the engineering persons were the ones that are responsible for determining, design specs and so on for a plant going forward, so not, withdraw that earlier comment. But the life of the plant is standard for medium-speed diesel, and that's what we use both in our assessments for planning, as well as in the depreciation study.
Mr. Blackman, this is an area of specialty for me, so I don't want to be unfair. I'm asking you, there's several factors that are taken into account when you're coming to life estimation.
Okay.
I'm asking you, if you don't know, I can have that for other persons that come in, because I'm not here, they told you from ball one, to ask you questions that you don't, that I wouldn't expect you to. In determining that 25-year average service life for the Clean Energy Bridge, which you admitted was not part of your 2017 study, nor the updated study in 29, was Mr. Huck involved in that, in estimating that life? And if not, I would just want you to let me know the persons who this question, because I want to get to the bottom of that 20-year life.
20 or?
That 25-year life. Sorry, no, sorry, you're right.
Yeah, I will defer to the expert witness as well as the Director of Finance as it relates to depreciation.
Okay.
But I
Mr.
would
Chairman,
say
we can move on that, because
25
I have a lot for that.
Yeah.
We have, you can argue Dr. Elfar, my second
But
here.
I want to go on the record, 25 years from an engineering standpoint, certainly from
Uh-huh.
a planning and engineering standpoint.
But if you start that, I'm going to have to cross-examine you.
Well, feel free to.
But I'm
It's
saying to
entirely
you-
appropriate for a plant of this nature, based on my expertise and knowledge in this area. A 25-year life for a plant like this is entirely appropriate.
I will give you the option to revisit that.
That's fine.
I'll give you the option. I'll be kind enough to give you the option to revisit that, because when we finish with that, I'm sure you'll have a different perspective. Now, Mr. Blackman, could we leave the steam plant and the Clean Energy Bridge, which the chairman wanted me to leave for a little while, because I think they're well aware? Could we turn now to the self-insurance fund? So, Mr. Blackman, I think Commissioner Martin is very early on. I did try to get an idea of if any actuarial analysis was done on the plan. I think at that time, if I recall, I think you weren't clear, but I don't think she got an answer, and I certainly didn't get one. Have an actuarial analysis ever been done, and when was the last one done? I just want to be clear on that.
Yeah, the last one was 2018.
2018?
In Core Logic, and that was submitted in evidence in response to interrogatory. And we referenced the one before that, and I believe there was a request from the Watson-Simpson team.
And this was the actuarial study that was done?
That's correct.
Right.
Risk assessment.
Yeah, because she asked that about something, I didn't get that. No.
Okay.
Mr. Blackman, is it correct that?
I'm just,
Yes,
Good
sorry?
ask.
Mr. Blackman, on a point of clarification, on Friday you stated you could not
go
say
ahead.
for sure whether an actuarial analysis was done.
That's
That
correct.
what was done was a report by your risk assessor, CGM Gallagher, and your internal asset management team. There's a difference between that and an actuarial analysis. Was an actuarial analysis for the fund conducted?
To the best of my knowledge, no. The risk assessments were done by expert insurance assessors.
Commissioner, thank you for that, because I thought ProLogic was that. So I'm glad you clarified that for me, because I was leaving here thinking that. And because I'm not here for any, they just want the facts as they are. So on record then that you have not done, that none was done to the best of your knowledge, just so that I don't go miss.
yes,
Yeah. thank you.
asked and answered.
That's it, thank you. Mr. Blackman, you mentioned that initially the fund, is it correct you answered that the fund had 730,000, that was the insurance at the time? There was no fund the insurance paid, because I'm talking about insurance and the fund both together. 730,000 back in 83.
No, I said that was what our insurance cost.
Your insurance costs, correct.
739,000, 739,000.
739, you know, but
Was a few, yeah.
now, Mr. Blackman, are you aware that from 1998, and I've got every single number here, I've got every hurricane that we had, I can say to every page in the document, are you aware that from 1998 all the way up to 2013, the insurance cover both the self-insurance fund and the general fund? In other words, the total insurance that the ratepayers covered would have been covered. Your charge every year would have been covered a total. So if I give you a couple examples, 5.581 million in 1998, that was the total insurance, of which 1.581 million would be for general insurance and 4 million went into the fund.
Yeah,
Are
so
you aware of these numbers?
Yeah, it sounds like you're combining the self-insurance with the third party.
No, I'm
insurance
just
to
saying
do a
what
total.
goes in, because if you go to your statements, you will see you show what goes in general and what goes in self-fund, because I went through all of them,
Oh, okay.
every single one. So from 1998, 1999, every year coming to 2021 that you just gave me. And if I stop at 2013, the charge for the insurance to the was, if you go at 2010, at that time, the insurance that you gave, 2009 for argument's sake, would have been 12,919,000, comprising 5.25 million and 7.6 million for the general fund. So the ratepayers at that would have been paying this money every year in the insurance. Is that correct?
No, that's not correct. Not
Are
to the
you
best of
saying
my
that the expense that came into the test year was less than the amount that covered both of those?
Which test year are you?
This is the test year of 2008, where
Oh,
the
2008 is, when you asked about the $730,000, that's 1983 that we're talking about.
no,
Test year.
sorry, I want, no, that is gone now. We are
Okay.
now coming forward now nicely, year on year.
Okay.
Right. So I'm not 2008 for your test year. Are you saying to me that the insurance expense in 2008 was not 12,466,000?
That is the correct number.
Right. And that comprised of 7.656 million for the insurance fund,
Yes, yeah.
and
And one, yeah.
and the difference 4.81 million for the general fund.
Sounds about right. yeah,
Right,
that
now.
year.
So, Mr. Blackman, so would you agree that the ratepayers then would have been paying the insurance, both the general insurance and the self-insurance fund, all along, year on year?
From 2009?
No, from, I
2010.
told you that, go back from 1998. All I'm
No,
saying
no.
is that in the test year, is there because you have the same insurance in your expense every year in the audited financials, both in the regulatory accounts, both in the non-consolidated financial, and when I got them in the published, because I cross-check out.
Right. They were, it was put into and built into the rate request and the rate ask in the 2009 rate case, but it hadn't been prior to that.
Right.
So
Prior to that.
prior to the last rate case, it wasn't in. I gave the numbers a little bit earlier. I've given them a few times, actually. But from the rate case, yes, the contributions to the self-insurance fund were built into the rates and the determination of rates in the last rate case.
You have to help me,
No
Mr.
problem.
Blackman.
Yeah.
The company would normally pay insurance, and if I understood you, is it correct that you could not have got that insurance in 93, anywhere around there with Hurricane Andrews? Is that correct?
Not reasonable.
Right.
rates, yeah.
So if you could have got that insurance, you would have paid the money to those to the insurance. If you could have got them, is that correct? If they weren't prohibited, you would have had the insurance company, you would have paid.
That's correct, yeah.
Right. Just as you pay for your insurance.
Yeah.
So as far as it's concerned, this idea that the insurance, which is an expense of the company, that expense, whether you pay it in the self-insurance fund or to an external party, that's an expense going to be on the part of the company. Is that correct?
Yeah, all of it is an expense that
To the company.
has.
So had you paid that to an external company, the same expense that you eventually go out and come to rates with, the only reason you didn't come to rates because you didn't have rates from 1983. That's the only reason. But as far as we're concerned, the rates you were collecting from the company, is that correct? Were the ones that out of which, because you don't get money from anywhere else, was paying that fund. The only money you get comes from the customers. Unless you told me you issue shares or debentures or something.
But
the only money comes from the, is that correct?
Well, during that period, I'm not absolutely sure. I mean, I would need to go back and see what happened with shares and issuance. I'm not certain from 83 all the way through. But what I can tell you, as I've indicated before, is that the insurance costs at the time that rates had been set in 1983, coming all the way forward between rate cases, accounted for about $20 billion.
All right. So,
However,
Mr. Blackman, I don't think that is the question that
you got me, Mr.
Mr.
Chairman.
is actually asking. When you applied back in 1983, yes, your insurance might have been $730,000. The question that he's really asking is if the payment for insurance annually comes from the revenue that is derived in the company. And that, I think, that's the question that he's asking.
Yes.
So that the revenue
yes.
actually comes from the ratepayers, and out of that revenue, you pay your insurance expense. That's the question I think he's asking.
The answer is yes, yeah. And all other expenses.
But Mr. Chairman, not only would Mr. Brown be a student of yours, so too would be me. I mean, I couldn't have asked it clear. So what we're saying is that in part of your testimony, I thought I was hearing funds injected by shareholders. And I didn't mean, I wrote in my notes very clearly, by shareholders. The money that was paid for the insurance all through the years was paid from the revenue collected from the customers. Is that correct?
Yeah, all of generally speaking, the revenue received by the business is from customers and the sale of electricity. Once that revenue comes into the business, then it goes various places. It goes to serve the capital, the equity in the business. It goes to serve the loan of the business, and then, yes, expenses like staff and insurance and other things.
Right. So thank you, Barry. I have a better clarity now because I was getting something yesterday that shareholders putting this money and so on, and now I'm clear now. Thank you for that.
Mr. Wang, if you
don't
mind,
ahead.
if I could intercede,
Sure, anytime.
I just like some clarity, Mr. Blackman. I asked you this question on Friday. You told me on Friday that the shareholders had acquired the interest in the trust when they purchased the shares, which is not technically correct because the only people that legally could own a trust would be trustees who own the legal ownership of the property and the beneficiaries who are entitled to the benefits. So therefore, your shareholder could not have acquired an interest when they purchased. Agreed?
I think I agree with your statement there, yes.
So further to Mr. Wang's point, when I asked you if any of the money came from the ratepayers, you told me no, that it came from the shareholder, that was money the shareholder put into the insurance cost. But that no, based on your last response, is not correct either, is it?
No, I actually, when you asked the question on Friday, I think I did agree with you
No, you
that
did
revenue
not, Mr.
came.
Blackman.
Well, we could look back. I did agree because after the fact, I felt that I didn't appropriately answer because I didn't speak to the source of funding for the business. I did agree with you that our money comes in from customers for the sale of electricity, but I felt as even after answering that way and agreeing with you on that point, that it was an incomplete answer that I gave, simply because the fact that money is paid into the business for a product that we sell doesn't mean that having received that money and having delivered that service, that the customer owns the business or the products in the business. They're paid for a service that has been delivered and given. So I felt I had given an incomplete answer because the source of funding, as I would have indicated either today or yesterday, is really out of equity and loans and customer deposits for capital in the business. And the equity is made up of retained earnings. And so I felt I was completing the picture by giving more information today and yesterday.
Oh, to Mr. Brown, my question was solely in relation to the self-insurance fund. I didn't ask you about your funding for the business.
Okay.
I asked you where the funding that is
Where
paid
the
into
money-
the fund came from, and if any came from the rate base.
From the base
What the
rate.
ratepayers, and it was part of the rate base that was paid by the ratepayers. That's what I asked you on Friday.
Right, and I think I conceded that the money that came into the business would have come from, it came from the sale of electricity to customers.
Finish, Commissioner, please. I have a fair amount to close out this self-insurance fund, because I got to get to all these issues that were nagging me, like what Commissioner Martinez just helped me to clarify. I'm noticing we're after 4, if my timing is right. Would you want me to continue, or what do you want me to do?
Not, we'll probably ask you to hold, but I just have a question for Mr. Blackman. Mr. Blackman, in terms of your responses to some of the witness, I think sometimes it might be better for you to explain in terms when you talk about sources of funds, because is it funds for capital expansion or funds for normal operations? And I think that is where the confusion is coming, because funds for capital expansion will come from loans, debt and equity sources. But I think some of the questions that are being asked is really relating to funds for
Expenses.
operations.
Okay.
Right. So when you say that your source of funds is capital and equity and debt, that is where you may mislead the intervener in terms of how the funds are being sourced. So I think you should try to make the distinction between operational costs and your financial management, and that would make it a little clearer. Or you may defer such questions to your finance person who may better understand some of those particular issues.
Point taken and noted, Chair. Thanks.
Thanks. So the time being 4:14 p.m., I think we will adjourn for the evening.
Thank you, Mr. Chairman.